Thank you very much. Hello, everyone. I have the green light to go ahead. Thanks for waiting for a minute or two while all the technology is lined up. We're delighted that you could all join us for this conversation, this seminar on trade in knowledge and the IP dimension of trade in knowledge today. This forms part of a series of webinars we've been putting together to mark 25 years since the WTO's intellectual property agreement, we call the TRIPS agreement, since that entered into force and helped shape the, if you like, the legal infrastructure of the knowledge economy. It's part of a series of webinars, but for me, this one is particularly special because it goes back to some fascinating conversations held among colleagues for quite some time. So the genesis of this program reaches back several years, as we've discussed with colleagues, with experts, some of the really important developments in the way that knowledge and creative content are shared and traded in today's economy. And I'm pleased to say that some of the most stimulating of those conversations was with our coordinator today, Jayashree Wattal, who will be moderating the second session, who recently retired from the WTO and has been a collaborator in this project from the very beginning, and who is also demonstrating that retirement is something of a fiction, because we're very grateful that this very active expert and professional and teacher is able to join us for the second session and to guide us through the conversation. Why is this so special? Well, since the TRIPS agreement was concluded, the text basically of this treaty was concluded in the early 1990s, even more than 25 years ago. And in that time, there's been, of course, a fundamental upheaval and transformation in the way that we share creative content, the way that we access knowledge, the way that we share knowledge. It's through the very technologies that make us able today to welcome you all here, or virtually here, and to bring together an incredible range of expert speakers from across the globe. I often remark that there has been a curious irony because it was here in Geneva, as the negotiators were putting the finishing touches to the TRIPS agreement, to the treaty language, just down the road, literally a tram ride away, Tim Berners-Lee was in the process of inventing the World Wide Web at CERN, at the European Nuclear Research Institution, CERN, quite literally just down the road. And yet, through no fault of their own, the TRIPS negotiators really couldn't foresee the incredible transformational impact, not only of digital technology generally, but of the World Wide Web, that this would exert on the whole field of intellectual property and the way that we deal with, access, share, creative content and technical knowledge. So it's something of an irony that these two developments were taking place cheek by jowl, very close together. But in fact, what we're trying to do today, I suppose, is to bring them together and to reflect on the convergence between the elaboration of intellectual property rules and standards on the one hand, and the incredible transformational effect of digital technologies on the other hand over these 25 years. So we'd like to progress a conversation about what we can learn from these profound changes and the remarkable transformation in the ways that knowledge and creative comment are generated, shared, transacted, transmitted, accessed, because there can be, in my view, nothing more important in considering the knowledge component of development policies today. So we would like, even in this brief webinar, to reflect something on what these changes, what these evolutions mean for policymakers and for development policy in particular, now that we do know that policymakers place such an emphasis on the knowledge component of sustainable development. If you look at the United Nations Sustainable Development Goals, the SDGs, you will see express references to innovation and to a whole host of areas where knowledge, where new technologies, where the access to new technologies are critical to development aspirations. This seminar doesn't come out of the blue. It builds on and it contributes to our ongoing work here in the WTO Secretariat to update and broaden our outreach and our capacity building on exactly these questions, on the policy and development implications of the intellectual property dimension of knowledge flows. And indeed, we're still grateful for the participants in an earlier, a 2018 seminar on intellectual property and knowledge flows in the digital era. And it also is foreshadowing something we hope will appear very shortly, an edited book co-edited by our co-coordinator, co-moderator, Jayashri, and myself on trade in knowledge, which will be published very, very shortly. I guess there's something of an irony that we are marking the incredible transformation, the digital disruption that has changed the way we access and share knowledge, that we're marking this by publishing a physical book. But this has been a very valuable way of bringing together some of the best scholars and experts and thinkers in this area and drawing them together. But the book is not an end in itself, and we see it as a platform, as a means of refreshing an important conversation about these issues today. So today, the panelists will be looking at the growth and diversity of trade in digital products, typically shaped by intellectual property rights, bearing in mind that when we download materials, when we purchase digital products, this is very often a purchase of an intellectual property license rather than buying a thing. Big issue we'll be discussing. More broadly, the trade in intellectual property products on digital platforms and the knowledge component of global value chains. So our panelists today will be exploring how intellectual property and licensing practices define and enable trade in digital products and support trade on digital platforms. And we hope to be able to talk about the importance of coherence with the international trading system generally, and to my mind, most importantly, the development opportunities that are presented. So as I've mentioned, this program is in part inspired by our forthcoming book, Trade in Knowledge. Watch this space, as they say, it is coming out soon. But we don't see this webinar itself as an academic symposium. All of us have been looking at these screens over the last year, and there's a great deal of Zoom fatigue. I'm with you there. So we don't see this as an academic symposium laying out detailed presentation of research. Rather, we're hoping to use it to open up and revitalize a more general conversation about trade in knowledge and its policy and development implications today. So we've asked our panelists not to go into enormous detail about their research, but to draw out the key elements and then to use that as a springboard for discussion with the panel of speakers and the Q&A session subsequently. Please bear in mind that if you want to put forward questions, comments for the panel to consider, you can use the chat function on Zoom or on YouTube if you're using that, and we will be collating your comments and questions and putting them to the moderators and to the panelists for your response. We're incredibly grateful for the choice of panelists who've been able to join us. We're thrilled that such a remarkable range of people in enormous demand, have been able to join us. One of our challenges in preparing for this is that they're such dynamic people. Pretty much all of their CVs need to be updated because they're in such demand and they are going places. I won't spend more time going through their biographies in detail. They're too impressive and too extensive to take up the limited time we have available. I do invite you to consult their biographies because we are truly very fortunate to have such a remarkable group of people joining us. That said, if you look at their positions and their achievements, do bear in mind that we're asking our experts, our panelists, to speak today in their personal capacity. So please do not take anything that's discussed or proposed or commented on as anybody's official position. This is an informal conversation and intended to promote dialogue rather than to lay out any kind of official positions. On that note, I should mention something very important. This webinar is it's part of a much longer running project looking at the question of trade in knowledge, and we won't be addressing the specifics of the current urgent pressing challenges, particularly regarding the response to the COVID pandemic and the current urgent issues relating to vaccine technology. This, I can stress, is not because this is not important. Of course, far from it. It's the exact opposite to that. It's because that concern is the subject of very intensive, very widespread, very high-level work being undertaken right across the multilateral system, in particular at the government-to-government level, and involving many key players in the multilateral system in what is a fast-changing, very complex, very dynamic environment. I wanted to say this up front so that there's no misunderstanding, because we won't, in this particular webinar, be able to engage in what are clearly very urgent and complex questions. If anyone taking part or in the audience wishes to follow up on those questions, please do get in touch with us. Lots of people are understandably getting in touch with us. You can contact us most easily by emailing ipd@wto.org. Because I can assure you that right across the multilateral system and in the WTO, the response to COVID is a very, very urgent matter. But that's not our subject for this particular webinar. So you've heard more than enough from me. It's my pleasure now to introduce our first panelist and speaker, who comes from within the WTO, but a leading international expert in his field, Jocelyn Madeleine, who is an economic affairs officer in the Trade and Services and Investment Division here in the WTO. Jocelyn, I hope I can pass the floor to you now with thanks.
Thank you, Tony. Can you hear me?
Absolutely. Yes. Please go ahead.
And see me. Okay. So thank you very much, Tony. And good morning, everyone, and good afternoon for those on the other side of the world. So first of all, let me thank you, Tony, as well as Jayashri, for inviting me to participate in this very exciting event, this webinar, on the occasion of the 25th anniversary of the TRIPS agreement. Now, I will share a few slides with you to structure a little bit what I wanted to present today. Can you see my screen? Yes, okay. So I will start this webinar by giving you a few thoughts as to what can we say about cross-border knowledge flows based on balance of payments and other statistics, and also pose some important questions as to whether statistics are enough to actually understand the cross-border knowledge flows or trade in knowledge. unfortunately, the shortage of data makes it difficult to answer important policy questions. And in the field of intellectual property, and in particular in the field of trade in knowledge, we do not have many data available. And for a long time, we were only able to identify one entry in the balance of payment statistics, which made it difficult to understand what this trade was all about. Now, however, we have seen in recent years some recent guidelines, statistical guidelines, that have tried to better capture the knowledge dimension in trade statistics, at least conceptually, because in practice, unfortunately, still not much progress has been made in terms of data availability on when it comes to trade in knowledge. And also another factor to take into account is the way the companies operate, which may also make the life of compilers extremely difficult to be able to compile relevant statistics. So, what are trade statistics that are available today? Well, we have trade in merchandise statistics and trade in services statistics, which with various ways of presenting them. And the idea being, well, trade in intellectual property or trade in knowledge is embedded within trade in merchandise or trade in services statistics. So the question is, how can we derive information which is relevant for what we're discussing today, in both in terms of value, but also in terms of origin and destination of the flows? Economic statistics break down intellectual property products in four main groups: computer products, audiovisual and other cultural products, products originating from research and development, as well as marketing products. So this is how statistics actually define intellectual property products. Now, as I said in my previous slide, we should start thinking about what can current data tell us. Well, when it comes to goods, we will focus on the importance of IP by focusing on exports or trade in high technological products. These are products which include a very large share of intellectual property. So that's why we would concentrate on those. Doesn't mean that other types of goods do not also include intellectual property rights, but high-tech goods most likely include a significant share of intellectual property in their overall value. And what we see over the past 25 years or 24 years, because the latest year for which data are available is 2019, is we see that there has been a very big increase in the value of exports of high technological goods, which is almost 3 times higher today than the value was in 1995. And we in particular see that the participation of developing economies has increased substantially, as shown on the last row of this table. In 1995, the share of developing economies in total exports of high-tech goods was 28%, and today it's more than half. They have surpassed the share of developed economies. So we can see that this is an important topic for all economic groupings around the world. But of course, as I said in my introductory remarks, different types of statistics can be used to assess the importance of intellectual property or knowledge in international trade. And now let's turn to trade in services statistics. Well, I will not go through, because a number of items in the services account of the balance of payments are relevant when it comes to intellectual property flows. But I will focus here mainly on the charges for the use of intellectual property, which is basically the payments or receipts that are made for the use of intellectual property, for distribution of this intellectual property, or for reproduction of this intellectual property. Other items, other services items that are relevant are in the balance of payments are computer services, audiovisual services, or research and development services. But here I will focus really on the charges for the use of the IP to show how important and how the increase of these flows has been important in the past 25 years. And what we see on this chart is that We have grown from a value of around 50 billion US dollars world international transactions relating to charges for the use of intellectual property up to 25 years later, up to 400 billion US dollars, which represents approximately an increase of 8% per year, which is a very high increase. 8% compares to 4% on average for services overall, and more or less the same value for goods. So we see that, in fact, intellectual property or charges for the use of intellectual property have increased almost 2 times faster than the value of commercial services trade, as well as trade in high-tech goods. So probably something to pay particular attention to. But the problem that we see here is that we are not able to identify what is the actual type of knowledge charges for the use of intellectual property that are charged for. Are they related to franchising and trademarks, to outcomes of research and development, or to the distribution or reproduction of computer software, alternatively audiovisual products? We do not have this breakdown. And as can be seen in the next slide, unfortunately, not many economies actually report details on these flows. So we do have an idea of the overall value of charges for the use of intellectual property. So we see here that more or less between 150 and 160 economies around the world report a total for charges for the use of intellectual property. But when it comes to the breakdown or the identification of a more granular view of these types of flows, well, unfortunately, the figures fall. We have less than 20 economies reporting the details of their charges for the use of intellectual property, which makes the analysis of these flows very difficult. So we know that trade in knowledge has increased substantially. We do not necessarily have a clear idea in which areas, although, of course, we have some anecdotal information that helps us understand this. And many experts around the table probably have a clearer idea than what statistics currently tell us today. But we need to start thinking now, what is a way forward to improve our knowledge on trade in knowledge? So a way forward would first and foremost to implement the recommendations, the international statistical recommendations, which are the Balance of Payments Manual and the Manual on Statistics of International Trade and Services. So implement these recommendations so that we could get more details according to the table, the details shown in the table in the previous slide, so that this would become available for a larger number of economies. Also, it would be necessary to map the emerging business models. We hear a lot about global value chains, but it's not totally clear at the moment how the knowledge flows or cross-border flows take place within these global value chains. So we need to map these emerging business models to better identify what needs to be measured. Also, we need to also discuss or identify the issue of transfer pricing as opposed to market prices, and also take into account what I was saying in my first slide or my introduction, the fact that many economies or many companies established in various jurisdictions, basically having in mind the benefit optimization, which makes it difficult for statistical compilers to actually identify these flows and compile them in relevant statistics for policymakers. We also need to find synergies in existing data collection systems, because some countries or some ministries do have some data, but not necessarily fitting the international statistical recommendation. We also need to understand better who is trading. So in that context, develop statistical frames for trade by enterprise characteristics, so that we can then know if it's more small and medium enterprises, which are important actors in this field, or larger economies. Also, if foreign ownership in companies is an important factor. We need to foster national and international cooperation in the statistical domain. And finally, we need to develop an international data set on intellectual property products and analyze the intellectual property in the context of trade in goods and services, what we call the trade in value added. So what is the value added brought by knowledge in trade statistics? So I will stop here, and looking forward to this very interesting webinar. Thank you.
Thank you very much, Jocelyn. Really, that was an ideal presentation for us. You've set out the facts very clearly, the facts that we have, and the undoubted question that this has become increasingly important, not merely for the international economy, but for developing countries in particular. But also, you've pointed to the need for further work ahead to build a stronger empirical foundation, and some very concrete proposals there. And there's plenty to feed into the conversation subsequently. I should have mentioned that the order of speakers is not entirely random, in that we've taken into account the challenges of time zones, and in particular early mornings, and so you'll be hearing more from the Western Hemisphere later in the session, out of respect for those who are still letting the caffeine bring them up to life, if you like. So our next speaker is a close neighbour of us from the University of Lucerne here in Switzerland. Again, one of the leading analysts on digital trade issues, and indeed has been an important collaborator putting together a major database. Professor Mira Burri, now at the University of Lucerne. Mira, over to you.
Thank you so much, Tony. I would just also briefly share my screen. All right, so ladies and gentlemen, dear colleagues, I'm absolutely delighted to be here with you today, and very grateful for the invitation and this opportunity to contribute to the webinar. So my presentation has basically two objectives. The first one is really to trace the evolution of rules on digital trade and data flows in particular across different free trade agreements, so outside of the multilateral forum of the World Trade Organization. And the second objective really is then to ask what the existing framework means actually for global data governance. My starting point, and the starting point indeed of the entire event, is the impact of the digital transformation. And we have had many different terms used in the trade policy discourse. Global value chains were already mentioned, but convergence was one of the first sort of buzzwords back in the 90s. Surfacification is one other word. Now, increasingly, there is a focus on data being as absolutely essential to the data-driven economy. We are all well familiar with this mantra of data being the new oil. And although it is a somewhat flawed statement, because data is not necessarily exhaustible and may lose its value over time, just this statement is very illustrative of the centrality of data for contemporary economies, as well as the push that we have seen both in governments as well as, of course, in companies to make the best of it, to make this data-driven economy real. What is quite critical in this context is that the growing importance of data has had this implication that it must flow across borders. Otherwise, many of the things that we are used to, even in our everyday lives, such as the app economy or streaming services or outsourcing certain services, might actually not work. And if you think down the road about the development of the Internet of Things, of artificial intelligence, all those groundbreaking innovations might not be working if we do not permit the free flow of data. At the same time, however, allowing this is not very easy because big data analytics, they open a number of regulatory questions as to the balance between access to and control of the data and the protection of privacy, national security, and other societal values. Furthermore, as you know, as when the data leaves the country, there are many jurisdictional issues that arise. And what this has led to is a sort of a new discourse, new discussion around data sovereignty or digital sovereignty, which is also related to the erection to new digital trade barriers, mostly here typified by the so-called data localization measures. So now let me look very briefly what have been the trade policy responses to digital transformation. Of course, one starts such a conversation by looking at the multilateral forum of the World Trade Organization. However, as we are all well aware, the rules under the umbrella of the WTO have not been adapted in a way to address digital trade and many of the issues that digital trade has brought about. And in the past 20 years, what we have actually seen is a sort of a venue shopping, forum shifting towards free trade agreement. And as Tony pointed out, I lead a project that has been dedicated to mapping and tracing these developments in free trade agreements with regard to the data economy, with regard to digital trade in particular, by looking at each and every agreement and coding it so as to see which are the rules that are relevant. You see here that a great number of agreements have dedicated digital trade rules, and there has been a sort of an evolution over the years. So we have more words, more provisions, more binding provisions with regard to digital trade. So normally when one looks, of course, at a free trade agreement, one covers all the chapters, or the dedicated e-commerce chapters, the services in trade chapter, as well as, of course, the intellectual property protection chapters. My focus today is mostly on the e-commerce chapters, because they have become a major platform for new rulemaking with regard to digital trade and data flows in particular. This said, it should be acknowledged that still the number of agreements that address data flows and the issues around data flows are still only a handful. So only, as you can see here on the table, only about 30, and only the most recent agreements have such norms. What is quite interesting also in recent years that we have seen the development of distinct templates that try to address digital trade. So of course, one has been driven by the United States, starting with the digital agenda, and over the years really framed in the TPP negotiations. And now recently also the European Union has sort of developed a clearer stance on digital trade and data flows in particular. So what you see here on the slide is sort of a summary of the issues covered in the CPTPP chapter on e-commerce, which is a verbatim copy actually of the TPP chapter, so not much has changed after the withdrawal of the United States. A great number of digital trade economy issues are covered in the CPTPP, and it creates an important template that has been also then diffused in other agreements. For our conversation today, what I would like to highlight are the rules on data flows. And there it is quite clear that the CPTPP seeks to sort of really restrict the use of barriers to data flows by having an explicit ban on data localization measures, and including also a hard rule on data flows, in the sense that each party shall allow the cross-border transfer of information by electronic means, including personal information. There are certain restrictions that are permitted for legitimate purposes. Here, the CPTPP and a great number of other agreements sort of imitate the legal tests that we have under Article 14 of the GATT and Article 20 of the GATT. However, the leeway is somewhat larger for the parties of this agreement, because there is no mention of the particular legitimate objectives. It is typical for the WTO texts, of course. What is interesting in this agreement is not only about setting higher standards and clarifying some norms coming from the WTO, it's also about sort of interfacing domestic policy regimes. And we see this here very clearly with regard to personal data protection. And what the CPTPP actually does, in a sense, is to give priority of trade over privacy rights. Of course, you can see later on, this is problematic for some other countries. The diffusion of the CPTPP template is quite striking. So a great number of subsequent agreements basically copy-paste the same language, including hard rules on data flows and a ban on localization measures, and the new digital trade dedicated deals go even beyond that. Now, what is interesting is with the USMCA, with the updated NAFTA between the United States, Mexico, and Canada, is that we have now clarity and certainty about the position of the United States with regard to digital trade. And this agreement basically goes along the lines of the CPTPP. However, interestingly here also includes references towards certain privacy standards coming from international and regional bodies, as well as for the first time in a US agreement, acknowledges some of the key principles of data protection, such as limitation on data collection, data quality, etc. It has been argued in the literature, what is why is this norm there, whether we are seeing a sort of a Brussels effect involving where basically the EU exports its higher standards of protection, or whether indeed we are seeing a shift within the US privacy protection legislation as well. Now, to somehow show you how the EU has done with these issues very, very briefly, the EU typically was rather slow and cautious in its reaction towards digital trade, and basically included sort of GATS-like commitments and not so many binding commitments. This is now radically changed in very recent agreements. We have provisions on data flow, so a hard rule, as well as a commitment to banning data localization measures. However, and this is quite a big however, this all is paired with the high protection standards of the EU General Data Protection Regulation, which basically endorses the protection of personal data as a fundamental human right, so very different as to the approach that you saw before. We have seen this new language, this new treaty language of the European Union in the currently negotiated deals with Australia, New Zealand, and Tunisia, which also include a very broad carve-out under the right to regulate. So many more safeguards on the side of the EU. This model has been now confirmed, sort of endorsed in the post-Brexit Trade and Cooperation Agreement with the United Kingdom. Just a very brief word on the RCEP. So it's a new model, a very recent agreement, including, of course, China for the first time in such an agreement. So it was very interesting to see how these norms on data flows are going to look like. What we have there under the RCEP are sort of provisions on conditional data flows. So what has happened is that we have a ban on localization measures, but there is so much policy space that is carved out for the RCEP parties that we don't know exactly how this is going to work out in practice. And very different from both the EU and the US agreements here, the tests are more or less self-judging, so the RCEP party can decide on the necessity of certain measures, and even with regard to measures for the protection of essential security interests, such measures cannot be disputed by the other party. So you can see how well protected this domestic policy space is, and basically it can permit for China, the Asian countries, and others RCEP parties a number of current as well as future restrictive measures to digital trade and data flows. What are the implications of all this divergence that we see for the multilateral form of the World Trade Organization? It might be, of course, those positions are also reflected in the submissions to the WTO Joint Statement Initiative negotiations. And what we see is this, that divergence may not be overcome, or may be very hard to overcome. And what we might have in the end is an agreement that is actually quite thin on the substance and does not promote cross-border data flows effectively. So just to sum up, over the past 20 years, what we have seen is the emergence of a specific trade regime outside of the WTO that is tailored for trade in digital products and services, which also addresses a number of the new issues coming from the data-driven economy. We do have agreement on some issues as to the enablement of digital trade, such as paperless trading, electronic contracts. At the same time, however, we have this disagreement with regard to data flows and the protection of important national interests. At the same time, simply because the data-driven economy has become so well developed and embedded in all societies, there is a need for enhanced international cooperation. So this is where I stop, and I would be very happy then to follow up this discussion in the Q&A session.
Thank you so much, Mira, for setting out the evolving international framework so clearly. I think to simplify a very complex set of phenomena, I suppose the internet hasn't, after all, abolished sovereignty, as it were, and there is still a well defended right to regulate at the domestic level. At the same time, you've pointed out the need, as must be evident, with something like the digital economy, for international cooperation and coordination. And you've brought us up to speed with some of the attempts, sadly for us, perhaps outside the WTO so far, but pointing to some of the really important trends in that area. So thank you so much indeed. Our next speaker, Keith Nurse, is the director of the Srinath Rampal Centre for International Trade Law Policy and Services at the University of the West Indies. And having really enjoyed his contribution to our book, I know that there'll be some really interesting observations on the significance of the digital platforms for the creative economy and possibilities for developing countries to make better use of its potential. But Keith, it's probably better that you set out your findings rather than me mess them up. So Keith Nurse, over to you with much appreciation.
Hello, colleagues. Can you hear me?
Yes, Keith, coming through clearly.
Okay.
Thank you.
Great. Apologies. Murphy's Law, I suppose. I'm going to try and go through this as quickly. As you indicated, I think, Anthony, we've all progressed in our situations. I'm no longer at the University of West Indies, where I was the WTO chair for several years. I'm now running the St. Louis Community College in St. Lucia. And so playing more of an administrative role rather than my research role, which I so enjoyed as a WTO chair. What I want to talk about is, how TRIPS, copyright industries and so on have linked to the growth of the digital creative economy. It's great to come after Mira. Mira is always a hard act to follow. Only a few years ago, Mira and I did some work looking at the economic partnership agreement between the European Union and CARIFORUM countries, where some of these critical issues were brought up, where we focused on the trade interface between trade policy and the creative sector, particularly things like the cultural protocol and so on. So, and it was great to see Jocelyn grappling with the data for looking at this sector. Let me progress to the next slide. Sorry, I'm having a little bit of a challenge here. I think it's useful to start with Keith Maskas. There's a quotation from one of his recent publication where he highlights that copyrights sustain incentives to invest in creativity and build markets, which are particularly important for digital content. They facilitate contracts in which various contributors to creative digital products and services can share income and ownership. They also facilitate licensing and distribution across international markets. Now, what is important, I think, from this very short and focused quotation is that we're dealing with a whole range of tradables, much of which are invisible and very difficult to capture based on the existing data sets. And so I felt it was important to just come back a little bit and look at some of the key things that the TRIPS agreement brought to the area of copyright in particular. Coming out of the Uruguay negotiations, recognized that the Berne Convention in effect provided adequate copyright protection, but some of the new areas were needed to be established in terms of providing more substantive provisions under the Paris Act of 1971. And in effect, under Article 92, copyright protection extended to expressions and not to ideas or procedures or mathematical concepts and so on. Article 10, which I think was important, development, provides that computer programs such as source or object code shall be protected as literary works. And Article 10.2 clarifies that databases and other compilations of data are also to be viewed as copyright. And it also focused on creating a framework whereby computer programs and cinematic works in particular had the right to authorize or to prohibit commercial rental. And last point I want to make is in relation to related rights. Things like Article 14.1 allowed performers to prevent unauthorized fixation of their performance on a phonogram and other methods or other media, and broadcasting organizations shall have, in accordance with Article 14.3, the right to prohibit unauthorized fixation. And so these provided the framework, the scaffolding, basically, upon which copyright and the tradable elements of copyright were regulated. And then fast forward from the TRIPS agreement, I recall very vividly when the data started to be generated on the economic contribution of copyright industries. In fact, my first experience with this was reading a report from IIPA, the International Intellectual Property Association, mostly US-based, and they, in a report, indicated that the copyright industries in the United States generated more employment and particularly more exports than the manufacturing sector in the United States, and more than the agricultural sector, and more than armaments and so forth. And that the copyright sector was the largest sector in the US economy. And so, as you can see in the work that the World Intellectual Property Organization has done over the several years, they've highlighted the contribution to GDP, but also in employment, which I didn't include in this slide. And so countries like the United States and Korea and so on are at the upper end of the spectrum. But I've highlighted some of the Caribbean countries that are on the list. So you could see that St. Lucia, where I am, is actually third in the list in terms of the impact of copyright industries on GDP. But then you enter the COVID context, and even before COVID, as Mira indicated, when we capture data on the copyright industries or the creative industries, what are we trying to count? Or what are we trying to measure? Goods for sure, services, yes, IP, yes, but also data now, and increasingly experiences, because countries are utilizing copyright and IP-related assets to do things like brand their destination or to do IP branding of goods and so forth. And so you enter this realm of intangibles where we're talking about experiences. All of this has been accelerated now with COVID. And so we need to be thinking out of the box because our existing data capture methodologies do not allow us to understand what's happening in the global economy with firms like the ones that I have up on this screen. 10 years ago, most of these firms didn't exist or they weren't household names. They are all household names now. And it's transformed the way in which we look at the global economy, because in many respects, the copyright sector and the creative sector in particular confounds the traditional notion of economics. So many of the goods and services and IP assets are all circular, and they're not final goods and services as we've come to understand in economics. It's also that there is a whole range of means by which this content is monetized. And this is just in this slide to illustrate the difference between the different platforms in terms of income earning potential. So for example, YouTube has wide coverage, but a low payout scheme, whereas Napster has very low coverage, but a high payout. And so where do you pitch your tent if you are creative in terms of generating or monetizing your content? So do you want to put it on Napster where you get a high payout but low coverage in terms of market penetration? Or do you want to go to YouTube? So this is data from YouTube and the impact that it's had on digital music. What this data is showing is that music was responsible for 83% of the videos which have exceeded 1 billion views. So it's really creative content that is driving the traffic on YouTube, but also on the World Wide Web generally. And music is becoming more valuable year over year and increasing its share of total views. So the creative sector is a key driver of these areas of copyright and also of intellectual property generally. It must have been more than 10 years ago, I participated in a workshop at the OECD focused on knowledge networks and markets. And I recall very vividly saying then that, that we need to be focusing on the apps market. I don't think we understood what it meant back then, but this is what it means today. So for example, TikTok is at the top of the heap in terms of viewership, followed by Facebook, WhatsApp, Instagram, and Zoom is number 7, which is the platform we're using here today. And so in many respects, it's the access and utilization of applications that is the window through which people are consuming and distributing copyright and creative content. What's interesting about this, though, is that there is a great concern that a large share of the income that's being generated and the trade patterns associated with this are not redounding to the benefit of the creators, or what in literature we are calling the value gap, in that a large share of the income is skewed towards the platforms and less so towards the producers of the content. And so this is of increasing concern, hence the importance of the EU copyright directive, which is trying to put in place an orderly marketplace for copyright in the digital arena. When you look more closely at the copyright sector, and here I look at collections, particularly for music and royalty collections in particular, what you see is what you'd probably more than likely expect. It's that Europe and North America account for the bulk of the of the royalty collections globally, close to 80%. Asia Pacific is the next largest sector, with China dominating the scheme of things, followed by Latin America and the Caribbean at 5% and Africa at 1%. When you look at the data in terms of how collections relate to the average inhabitant in each of these regions, you could see that copyright has a higher level of valuation per person or per capita in Europe and North America compared to all of the other regions. And so from this standpoint, you can argue that there's a long way to go before we see regions like Africa, Latin America, and the Caribbean and Asia Pacific maximizing on the value of copyright in their domestic spheres. What does this mean in the final analysis for both the developed country parties as well as the developing country parties to all of the agreements that, for example, Mira spoke about? We need to be facilitating market access and market entry programs so that firms from the different regions can trade across borders. We need to establish funding to gear up and create a startup culture that generates increased competitiveness for developing countries. Things like visas for artists, touring visas are becoming really important. Mind you, COVID has put a stop to the mobility of artists and so on. And then provision of IP financing. So for example, collateralization of intellectual property, securitization of IP, and new methodologies which need to be embedded in developing economies to finance the sector to a greater extent. But there are things that developing countries need to do for themselves. They do need to boost their domestic content and facilitate the growth of creative and digital entrepreneurship. In fact, at my college, we are just launching into a program to train in this area. Establishing cultural observatories for data capture. So for example, in tourism, we talk about tourism satellite accounting. The same kind of methodologies need to be adopted in this new sector where the creative industries and copyright generate multiple income streams. And last but not least, I would say that the two key areas, we need to build competitiveness in terms of digital platforms and aggregators, not just relying on Spotify and Pandora and Netflix, but also creating platforms in the regional developing country spaces, and then strengthening copyright administration and rights management. Because ultimately, it is your capacity to collect your royalties that ensures that you are trading in this area. I'll end on that note and thank my colleagues for inviting me to participate in today's session. Best regards.
Thank you very much indeed, Keith. That was fantastic, and I think a really good counterpart, as you've suggested, to Myra's presentation, in that you've pointed out, okay, here is the legal infrastructure, if you like, international and national, but we've got to make it work. And you've mentioned some very important interventions and initiatives that can be taken at the national and the regional and international levels. And very much appreciate all your slides, but the last two that point to very, very concrete areas that we, in my view, we can and should work on collaboratively. Our next speaker, for me, captures the constant challenge we have in the field of IP policy. How can intellectual property experts speak with economists and develop a common lexicon? Sometimes we do seem to be speaking in different languages, but thankfully Stella Rubenova from the OECD now, until recently a colleague of ours here in the WTO, a very able, a very leading trade economist, has worked with us closely on IP issues. And so in particular, looking at knowledge flows. So Stella, very much looking forward to your presentation along those lines.
Well, thank you very much, Tony. I hope you can hear me well.
Yes, you're getting through well. Thank you.
Great. So yeah, I'm very happy to be here and for being invited and to be actually part of the continuing conversation that we have on this topic, and that certainly will go forward. So I'll try to quickly share my slides. And so compared to the speakers that preceded, Keith and Mira and Jocelyn, I'll take a little bit broader or step back and a broader view on trade and knowledge, and basically emphasize the importance of knowledge and technology flows for economic development, for economic growth, and of course the role that trade and global value chains play in enhancing these flows. So it's perhaps unnecessary to say, but still I want to emphasize that really innovation and technology adoption are the drivers of economic growth in the long run. So while economies can to some extent grow by accumulating physical capital or by making their allocation of resources more efficient, really in the long run, what needs to be done is to have continuous improvements in productivity, and only technology upgrading can lead to these continuous economic growth and productivity upgrades. And while in developed economies, as also it's obvious from Keith's presentation, it's really innovation and the primary research and really the creation of new knowledge and technology that drives growth. In developing countries, it's mostly the adoption of existing technologies that were developed elsewhere. So it's really crucial for developing countries to be able to sort of absorb and adopt the knowledge and technology that has been created worldwide. And I'll here just quote one study that basically shows that when we look at per capita income differences and how they vary across countries, basically around 25% or a quarter of these differences can be really explained by the extent to which countries adopted technologies that were available worldwide. And it's just even more important for countries that are still specialized in agriculture, because these technologies and technology adoption is especially important for agriculture. Of course, how trade comes into the picture, I'll sort of categorize the channels into two main groups. So one is that trade enhances the incentives to adopt new technologies and knowledge. And also it, of course, gives access to these technologies and knowledge. So let me first sort of elaborate on the incentives. So basically, adopting or upgrading your production technology is costly. So either a firm needs to invest in R&D and create its own new innovation, or it needs to adopt technology developed elsewhere. But even then, often that goes along with either upskilling your workers, hiring workers that know how to work with the new technology, changing your physical capital, investing in ICT infrastructure. It can also mean actually changing to some extent your production process, because new technologies might not be compatible with the old production process. So this is costly. And only if the market for the product of the firm is large enough, or the demand actually values potential new quality of the product, it is actually sort of profitable for the firm to invest into these fixed costs of adopting new technologies. So this is basically where the fact that trade enlarges markets for firms and potentially for firms from developing countries, it also gives access to demand that actually values quality more than or is willing to pay for quality. This gives firms incentives to actually invest into adoption of technologies and absorbing knowledge. So when it comes to the second channel, of course, access to new technologies through trade, obvious from Jocelyn's presentation, it can be either through direct licensing of technologies from abroad, or it can be technologies and knowledge embodied in goods and potential services. And there is a vast literature showing that indeed importing, especially technology-intensive intermediate inputs, enhances firms' productivity and also basically leads to technology diffusion. And this is really where the adequate IP system or IP rights system is very important, because for that to be trade in a technology or knowledge-intensive goods, the exporters of these goods needs to have their guarantees that that their IP rights will be respected. So I think this is really where already these parts are to some extent covered by speakers before me, and will be also covered by speakers that follow. What I would like to actually focus a bit more on is that even though many technologies are out there, are available for licensing, in a way, many parts of knowledge are actually widely accessible and codified. They often, not always, or they often that actually don't diffuse in a way that we would expect them to do so. And so basically having the access and even the incentives to adopt new technologies and upgrade is not always enough. And one of the reasons is that the technology doesn't only, or knowledge doesn't only have to be codified, but often there is an element that cannot be codified, that is tacit, and there is a know-how that might be crucial for implementing these new technologies. And for instance, do follow-up innovation on an invention that has been previously invented, often one might need to have access to this tacit knowledge that just needs to be communicated. And often that means interpersonal communication, and that means that such knowledge diffuses slowly across borders. And of course, tacit knowledge and know-how, since they diffuse mostly through interpersonal communication, typically they do diffuse through basically workers changing employers. There's a wide literature showing that basically a lot of technology that is first specific, or knowledge that is first specific, diffuses through workers just changing jobs and bringing their tacit knowledge and know-how with them. And accordingly, also, if they cross international borders, they help the diffusion of knowledge. But in the past 20-25 years, what we've also seen that with the basically unbundling of the production, that the ICT technology allowed the fact that production can be now sort of done in several countries across the world, and basically connecting firms from developing countries and developed countries through quite tight business linkages where a production needs to be coordinated across several countries. This has actually led to also much more flows of knowledge and much more communication. So this is something we have actually focused on in our research with a colleague of, or previous colleague of mine from WTO, Roberta Piermartini, was to show that basically these close interactions within international supply chains help also transfer this tacit knowledge and know-how, and so lead to these kind of knowledge spillovers, and that this actually boosts global innovation and innovation in emerging economies. So what we find is that thanks to knowledge spillovers that the global value chains facilitate, innovation on average was boosted by 5% between 2000 and 2010. And so I think I will kind of conclude with the questions for further research and sort of where we probably want to have more focus. One thing is that a large part of the literature that looks on technology diffusion and also spillovers within global value chains focuses on manufacturing. So we don't know very well what happens in services supply chains, and that has become, of course, thanks to digitalization, something that is an avenue for some developing countries to join global value chains. You can think of India in computer IT services. You can think of Indonesia in business process outsourcing. And we don't actually know very well whether there are knowledge spillovers in these services industries and to what extent. And more broadly, basically, what is the role for knowledge spillovers in the digital economy? On one hand, it's possible that digitalization actually leads to sort of more codification. So the tacit part of knowledge or technology might become less important, and technology might actually diffuse more easily because more gets codified. On the other hand, we've been also witnessing the sort of the adoption of digital technologies has been driving some wedge, even in high-income countries, between small and large firms. So often it's large firms, most productive firms, that actually adopt these digital technologies. And in the recent years, actually smaller firms have been lagging behind more and more in productivity, partially because they're slow digital technology adoption. And there you can think even further this in developing countries that can be even more exacerbated, because we know that even though technology actually arrived almost everywhere to some extent, it's often multinational companies in developing countries that adopt those technologies, and local companies still work with old technologies. So this could actually sort of patterns in digital technology adoption could pose further problem for the wider diffusion of trade and of knowledge. So I'll stop here and leave this for discussion. Perhaps. Thank you.
Thank you, Stella. Thank you very much. And indeed, as we'd hoped, you'd set out the issues, the economics of it in very clear terms that even I could understand, which is quite an achievement. And I particularly appreciated the contrast you drew between, what in IP terms we typically think of knowledge, of content in IP-sized buckets or packages, literally, packets of stuff that you license. But you've pointed to the really important part of tacit knowledge, or the transmission of know-how in that way, and the dilemma you pose at the end is, I think, incredibly important for us to reflect on. I particularly welcomed the reference to future research, because, as I mentioned, one of the aims of this webinar is not merely to refresh the conversation and to reflect on what's happened, but also to share ideas about directions for future research and for research collaboration, as well as policy conversations more generally. And so that's something for our concluding session. So we now can return back to Geneva, and indeed back to the WTO, Geneva, where so much multilateral work has taken place, or perhaps might take place in the future, on governance issues, some that Mara's touched on. And I'm pleased that our colleague from the IP division here in the WTO, Wolf Meyer-Ewert, is our next speaker, a councillor in this division, who will be talking about some of the international governance issues concerning intellectual property in the digital environment. So Wolf, with pleasure, over to you.
Thank you, Tony, and I hope you can hear me and see my slides. It's an honor to contribute to this. Sorry, can you see this? Can you see the slides?
Yes, you're getting through perfectly well.
Okay. Right. And it's a pleasure to be a part of this continued conversation. For this project, I looked at or attempted to look at international regulatory responses to IP challenges in the area of digital trade. Looking in particular on how regulatory responses at the international or multilateral level may evolve and spending a little time on some of the examples where this has already taken place. So in order to approach this, it was worth looking at the anatomy in a way of international regulatory responses historically. So how is international IP law made? How do we arrive at these instruments, and how they changed over time? And that, of course, is a bit of a historical sojourn, and it is also not an exact science, given that there are often different streams or developments taking place at the same time. But I think it's worth trying to identify some trends that can help us understand some elements that influence and that are different between different regulatory outcomes. And what can be identified as a general trend, and I think that's probably not a great surprise, is that we, particularly in the area of IP, international IP regulation, which started pretty early compared to other areas where international harmonization or standard setting came much later, that there was quite a significant period of what I call sovereign treaty making, well up until the 1980s, 1990s, about 100 years where treaties were sovereign, made by sovereign players in international organizations. The Berne Convention and the Paris Convention really are quite unique in the sense that they've sort of crystallized the place of where international IP law is made in the late 19th century, and that it stuck to this model, stuck for so long, even though there were some alternative models, but they didn't necessarily take off to the same extent of success that these conventions that were then later swept up into the UN system when the WIPO was created as a UN agency, that this dominated the treaty making for so long. I mean, to identify, just to as a kind of headline keywords here, these are of course done by sovereign nations, and they are usually agreed by consensus. They all have the approach that they regulate IP in a unified and universal kind of fashion. So this ambition to have a single set of rules or a relatively universal approach to regulating IP also lasted for a very long time. And the interesting aspect I want to highlight, which you see when you look at the details of the negotiation history, is that the roles that experts play in both the creation but also the revisions of these big conventions, because quite uniquely, the role of experts blends from national experts that come to the negotiations and contribute their national experiences, but very often blends into a real international expert exchange that has created, in some cases, actually new solutions to certain regulatory challenges that were first adopted at the international level and then triggered down into national law, rather than a traditional model where you would have imagined that common practices in a number of countries would ultimately bubble up to the international level where consensus would then be easy to find. So the role of experts is a particularly interesting element in this phase of sovereign treaty making, mostly in the context of WIPO, but to some extent TRIPS can be seen as the last emblematic element of this approach to treaty making. It's still consensual, it's quite universal. In fact, it succeeded in combining Paris, Berne, and other conventions, as you know, in a single legal system. What is also worth pointing out that at that stage, there was relatively, or up until that stage, there was relatively little trade-offs forced onto the IP negotiations, given that they were mostly negotiated in a single setting, something that will change quite significantly when we come down to how IP chapters and free trade agreements are negotiated today. So after that, relatively homogeneous phase, we can observe that gives way to a much more diversified scene of tools and regulatory approaches that are used roughly with the arrival of the internet. As I said, TRIPS in a way is a last example of this. It somehow overcame beginning signs of stagnation in the context of WIPO when further revisions of the conventions seemed very difficult, if not impossible. So TRIPS managed to do another kind of big sweep of consensual universal treaty making. Beyond that, we see occurrences of more single issue driven approaches. The first examples of these are the WIPO Internet treaties in '96, which are still, sovereign, consensual. So in a sense, they are traditional treaties. They have benefited a lot from expert development at the international level. They built on a lot of the work WIPO did in the 1990s already on internet questions and usage of IP rights on the internet. But they focus on a single issue. So the choice to have not a revision of the Berne Convention, but a separate treaty to which members can accede separately is quite a significant one. It is, to some extent, I guess, a realization that the big conventions became very unwieldy, and the multitude of interests that would have to be taken into account of doing full revisions make it very difficult to employ that approach. It may also reflect that there was these particular issues were ripe for decision because the urgency to have them regulated were sufficiently widespread. And of course, the mid-1990s were also a phase where international multilateral agreements enjoyed a certain heyday, from which also the TRIPS agreement and the Uruguay round in general profited. So the WIPO Internet treaties in a way are a regulatory response to digital IP challenges. So the question of the making available right, as we know, that was regulated or clarified in these areas, in these treaties, that putting your work on the internet was indeed an exclusive right that belonged to authors. The internet treaties were also an example where a solution was found at the international level and then subsequently implemented in national law. The two significant and early implementations of these internet treaties, the Digital Millennium Copyright Act in the US and the Copyright Directive in the European Union, of course, set the scene very much for many of the aspects that we'll talk about in a second. Other tools that were used, excuse me, and that came on equally, I think, reacting to the decline of revising big conventions or the willingness to tackle universal bodies of rules were non-binding instruments of soft law. I mean, significantly, WIPO passed two joint recommendations in the area of trademarks in 2001 and 1998, where members were no longer able to arrive to agree to a binding legal instrument, but were able to agree on a soft law, a recommendation that was based on, again, expert advice at the international level that could formulate recommendations and responses to challenges, particularly on how trademarks should be, trademark use should be assessed in the context of the digital world. And how violations could be determined. These were, again, still sovereign nations, expert-driven, single issue, but they were no longer consensual in the sense that they created binding legal standards. Another approach to certain elements were technical solutions. the technology itself, of course, the normative power of arranging things in a certain fashion is quite overwhelming in the digital sphere. And ICANN and the UDRP, the domain name dispute resolution system that evolved, that creates a kind of distinct technical solution to a very defined area of IP, namely the collision of trademarks and domain names on the internet, is very successful, benefiting no doubt from the clear delineation of the area where it's applied from the wider IP questions, although there are tensions with, as many of you will know, with the wider trademark law, but it has, I think, been extremely successful and continues to be kind of the mainstay of dispute resolution in the context of ICANN and domain names. And here, this is, of course, in terms of the typology, a non-state actor solution, which is run by stakeholder models and was developed through stakeholder input and focuses on a single technical issue. It does, of course, require kind of state intervention to regulate that domains are regulated by this particular dispute resolution mechanism, etc. But there are also private models where domain name distributors offer or decree that their contracts are tied to this particular type of dispute resolution model. So it's a further diversification of how of a regulatory response to IP challenges in the digital world. And then, of course, again, no surprise here, the dominant force in international regulation of digital IP challenges today are free IP chapters in free trade agreements that have risen so dramatically over the last 15, 20 years. And that increasingly, as you know, contain more and more elaborate IP chapters, just as much as they contain e-commerce chapters that Mira was talking about. Now, from the typology here, of course, these are sovereign country treaties. They are, of course, in a much smaller setting, bilateral, regional. And the IP chapters therein certainly are much more projection-driven than, if you like, in contrast to expert-driven of the multilateral system process that I laid out in the beginning. So the research shows, or the analysis of the text also shows, that the main objective, of course, is to project your own IP system into the partnering countries' IP system. That's particularly the case, of course, when there are significant differences in developments. New solutions sometimes are found when you have more or less kind of equal partners. So if you look, for instance, at GI solutions in CETA, these kind of things, these are actually genuine new approaches to existing problems. But in many cases, it is a projection of a certain standard that comes from a domestic implementation that is already in place. And the dynamic, of course, of free trade agreements is that the IP chapters they are much more prone to trade-offs with kind of non-IP considerations, be it in market access or in dispute settlement, etc. Free trade agreements or the IP chapters of free trade agreements are of course tied to the TRIPS agreement through the MFN and national treatment provisions, which do not have an exception for RTAs or FTAs, in contrast to the rules in GATT and GATS. So the substantive standards that are agreed in the IP chapters, they become binding multilateral obligations of these countries that have undertaken them. And through that, very often FTA's IP chapters refer to soft law or to provisions in treaties that not necessarily both parties are signatories to. So in that sense, the free trade agreements can actually be vehicles for the multilateralization of soft law. And that's certainly the case for the two WIPO joint recommendations, which, as I said, were non-binding recommendations when they were adopted in the early 2000s or in 1998. But they've now virtually become legal standards because they are included in the obligations in quite a number of FTAs. So here you could see that the international regulatory response to digital challenges is now much more diversified and in parallel compared to the previous phase of homogeneous sovereign treaty making. The different tools are used in parallel. There is potential for overlap, and it is quite interesting to look at the relationship or the results that these parallel tools might produce in different contexts. For lack of time, I'll just look at one example here that I looked at in more detail in the paper for this book, which is essentially ISP liability. As you know, the question of whether platforms are liable for the copyright infringement of the content they display, which is often user-generated content, is a major determinant for the viability of the platform business model. That has led many jurisdictions. I've mentioned the Digital Millennium Copyright Act and the early EU implementation of the internet treaties has led these countries to try and shield platforms from liability for such violations in order to encourage the implementation of such business models and active engagement in the internet economy. It's interesting that at the beginning of this implementation phase, there is still a quite animated discussion and plurality of legal approaches on how this could be achieved, because the question, of course, around platforms would first and foremost be whether a platform is indeed liable at all, so whether or not there is liability for the platform activity. And the second and quite distinct legal approach is whether you create a blanket shield for liability without actually addressing whether this question, whether the liability is there in the first place. And the early implementations in the US and in the EU have focused very much on the second approach, the safe harbor approach, whereas a number of countries that are not signatories to the internet treaties, in their domestic jurisprudence, you can still observe quite an animated engagement with the questions of whether being a platform actually means you're liable in the first place. Let's say the development at the national level to develop these safe harbor models has, in the absence of a multilateral regulation, translated pretty directly into bilateral treaties, where a number of treaties now have extremely elaborate systems of ISP liability in place that cement or project the safe harbor approach into the trading partner. And therefore create a kind of de facto international regulatory response that has come about basically by the confluence of these IP chapters in FTAs. That is interesting in terms of kind of the mechanisms of regulatory response. So there has never been a moment where an ISP or a safe harbor solution was considered in an international forum, neither in WIPO nor in the TRIPS context, where these discussed or the nuances discussed, because the models that exist around the world, even if they agree on the principle of liability shield, vary quite considerably, of course, in the degree of cooperation that the ISPs have to provide, or the degree of duties that the ISPs might still have to employ in terms of monitoring their content, which is, of course, in sharp focus of attention nowadays, when the platform business models are no longer the small and fragile business models of the early 90s, when they needed, which motivated the safe harbor approach in the first place, to try and give them breathing space and develop their business models. The second, more recent discussion that has added to a reassessment of the balance of obligations here is the value gap discussion, which Keith has illustrated. Let's say, a relatively intransparent distribution of remuneration within the different platform models, which is, of course, helped by the fact that they are not themselves responsible for copyright violation and do not necessarily have a monitoring obligation. In fact, the absence of the monitoring obligation is a common theme in the way that the ISP safe harbor has been described in the FTAs and RTAs that I've listed here. Even the EU FTAs, despite the fact that at the national level in the EU, the monitoring obligation was considered, let's say, more actively considered regarding the duties of the platforms than in the US, where this has always been rejected as being as being too burdensome for platforms to exercise such an obligation. Even the EU has put it in its bilateral treaties that a general monitoring obligation cannot be levied on to ISP platforms. These treaties have now been in place for a couple of years, and the most interesting recent development is, of course, that at the domestic level, the recent copyright directive for the digital single market represents quite a policy change with regard to monitoring obligations of platforms in Europe. So under the new DSM, it is now indeed considered that the platforms will have to take on more monitoring obligations in order to ensure that content on their servers is licensed and that they will indeed remunerate on a more reliable and verifiable basis. And it will be interesting to see how that tension with the bilateral treaty obligations, how that pans out and how that interpretation will go forward. So I think that looking at the international regulatory response to in the area of ISP liabilities demonstrates that the sort of diversification of tools and legal instruments has made the landscape quite a bit more complex and has, of course, also increased the potential for contradiction or tension between different levels of regulation. It is interesting also to look at other emerging issues in digital trade where, let's say, the regulatory developments have not that far advanced. Orphan works, online exhaustion, both are things that are extremely relevant for the online platform. It's interesting to look at the legal and regulatory developments in these areas also through the prism of whether and how they could end up at an international level. Let me close with a look ahead. It's clear that the diversification in regulatory responses, as I've said, has made the world more complex. I think what is worth highlighting is that it will also reach or necessitate regulatory responses in areas adjacent to traditional IP law, particularly data standards for smart contract and blanket licenses to IP works, as they've just entered into force in the US under the Mechanical License Collective, will require or will influence quite strongly how music works can indeed access markets, how they are remunerated, and whether they'll be considered for use by platforms on the basis of how their data is standardized and monetized in that regard. So I'll stop here. I think as Francis Gurry put it very nicely, this sort of diversified parallelism, I think, reflects the reality of a multi-speed and multi-tiered world in which multilateralism, while being the highest expression of inclusiveness and legitimacy, is nevertheless the slowest solution, and therefore leaves ample playing field for alternative tools and instruments. Thank you.
Great. Thank you very much, Wolf. Thank you very much indeed for that very extensive overview and going back to the roots of international IP law, but also reminding us that it's not only the what, the content of the norms, but also the how they come about and how they're diffused. So, indeed, your chapter in the book elaborates on this, and I refer that to those who will be, I hope, picking up the book very shortly. Now we move to the very far west of our geographical imprint. I won't say the Wild West, but Jeff Dodd has very kindly joined us from Texas, and where it's still very early in the morning, but an unmissable presentation because the work he has been doing together with our colleague Jacques de Verre it expresses some very interesting ideas on the future of contract law and the way we transact in IP across borders. So Jeff, without further introduction, I'll gladly pass to you.
Thank you. Well, I can say that there aren't many things that will get me up at 2 in the morning to talk about legal topics, and so, but this is one. This is a very exciting presentation. I want to thank you and your co-moderator for the invitation, and to all the panelists. I'm going to share my screen. Try to. Okay. And let me see if I can get there from the beginning. There we go. There we go. All right. So what I'm going to talk about is more on the commercial side. We've heard some excellent presentations on knowledge flows from an economic standpoint, some legal regimes and the like. But I'm going to focus more on the commercial side. I have 4 themes. And as has been emphasized all throughout these presentations, commercial transactions in information assets has grown exponentially. And what we see is that we heard about the treaties that are in place with respect to IP aspects, but and the fragmentation there. But we haven't had any uniform recognized set of commercial principles with respect to basically the contracting or the commercial nature of information transactions. So what you see is the growth of private ordering regimes or their emergence. I mean, that really revolves around several different factors, one of which is that information is going to flow. Information assets are going to be traded. They're at the core, information assets are at the core of modern business. And so you're going to see trade in it. And the issue is whether you should recognize general commercial principles around that trade or just allow private ordering to continue. The other thing that I think is a development that we'll maybe touch a little bit on is the very notion of what a product is changing. And you can look at a car, for example, as having an aspect of a physical asset, a good. But increasingly, cars are loaded with and are controlled by information assets. The computer information components are absolutely essential to the operation of the vehicle. And so, and maybe updates, maybe changes can be made to how the good operates by virtue of information downloads. So when we think about the interaction between what a product is, what a good is, what an information transaction is, this is in part going to be the subject of commercial transactions in the absence of in the absence of specific rules. So let's get into a little bit on. I'm going to skip most of this slide because I think we've heard from other speakers much more eloquently than I can put it, that there's a trade in information assets is increasingly important and will be growing apace. This is a digital world. This is a world where information freely flows. If you think about it, what makes this somewhat a unique time, if historically information would flow along the same lines as trade in goods internationally. I mean, the same modes of transport of information were deployed, and it's what we've seen because of technology is the disaggregation of that, so that you have information flows that have no tethering necessarily to goods flows. One thing I want to emphasize is information transactions are unique. They're a trade in a good is quite different than the trade in an information asset. And I'm not only talking about IP or identified IP such. There are hybrid transactions where IP is not even identified, and it is just as crucial. Licenses are the most common form of IP transactions. The statistics that we are able to muster, spotty as they are, bear that out. And there are several reasons for that, not the least of which is in a license transaction, of course, the licensor retains ownership. That allows segmentation, that allows control with respect to the underlying information asset to the extent it's there. And it also fosters different types of business models. So there are a lot of reasons why licenses have dominate in information transactions. If we talk about the architecture, if you look at the law such as it is, and the structure of licenses, they really take their form from the interaction of really three strains. One is intellectual property law, of course, although I would stress that there are many information transactions where the focus is not on the IP as such. Public policy, competition law, of course, is very crucial, and we've heard other legal regimes, but contract is the most important or the most dominant element, if you will, in a commercial transaction, commercial transactions IP, because it is dealing with commerce. The root difference of a license, of course, is that there are conditional transfers. As I mentioned before, there's a reservation. It's not, there's a reservation in the licensor. It's not a complete transfer. These transactions are a discrete category. Some courts don't recognize that or don't really fully grasp this, but it's really quite important to realize that there are some commonalities to the structure, the way a license is put together, for example, that aren't necessarily, they're not dependent on the information asset itself. It is also unique from a unique commercial transaction form and should be recognized as such. Because that's the commercial practice. It's like with sales. Sales are recognized as being a discrete transactional type and not necessarily dependent on the type of good. We don't have the sale of horse law, for example, or sale of gas law. There are aspects that do have unique tailoring to those particular forms, but there are overarching commercial principles that also govern the commercial aspect of trade in a good. The problem with the current state of the law, such as it is that there are a couple different approaches, and neither of which are satisfactory. One is to treat information transactions as if they are transactions of other types of goods. That's certainly the case in the United States. There are, you see various courts come out and treat them as if they are goods. But that's heedless of the unique aspects of the information asset. For example, should a sale of goods warranty attached to an information asset? I believe not. There might be different types of warranties or assurances or implied things, but they had to be tailored to the unique transaction and the asset, in my view. There's also private ordering, as I mentioned before. In some cases, it's formal, like standard setting bodies and that sort of thing. But in most cases, it's informal. There's an information law merchant that kind of is cropped up in different aspects. It's fragmented, it's industry focused, stitched together lore, kind of industry practice and the like. What that requires, though, is that specialized knowledge. I mean, you have to participate as one of these merchants, if you will, and very often, because there aren't necessarily specific background rules, the contracts tend to be more elaborate. You want to spell out the rules that otherwise you could rely or take advantage on a background principle. You don't have that necessarily, so you spell it out. So the result is barriers to entry and increased transaction costs. So it really cannot serve as a basis for or a legal foundation for a very fast growing, as we've seen or as we've heard, base trade in information assets. So what would if we're going to recognize some principles of commercial transaction information law, what would that look like? There are a variety of things. I've thrown out some ideas here. We could start with the base that most commercial or many commercial general principle regimes address, like formation issues, interpretation. There are some unique aspects, though, that would need to be addressed that don't necessarily come up in a sale of good or a general contract sort of commercial law. One would be, let's take a classic example. What does exclusivity mean? I wrote with my co-author who's passed away, but we wrote a book on licensing. And when I took the task of writing a chapter on exclusive licenses, and I thought I knew what exclusive meant. It's very uncertain. There are many different ways that one could analyze what that means. Well, you could have some general principles that will line that out so that there could be a common understanding. So that might be an example. There, at the very bottom, I mentioned other tougher issues. I had mentioned before the concept of basically how do you treat the interaction between information transactions and, say, other types of transactions, like sale of goods. I mentioned the example of a car or smart refrigerators. That the Internet of Things is going to make these set of issues come up repeatedly. How do you treat the differences between what might be an information asset and a goods transaction? And so if because there are different obligations that arise with respect to these unique assets, and there are lots of different answers that one could come up with, and I have some views on the subject, and I think there are some treatments around it, but it ought to be thought through in a careful way so that you understand the barriers, or the confines and the boundaries of the different regimes. You could look at it at a lot of different things. Well, I see automatic lights go off. At at this hour, what happens is you only have so often, and then the lights go down. So I look kind of spooky here, but I'll finish up on this note. I do think that trade in information assets is a unique and very important commercial arrangements that should have a general recognized common principles that one could look to across boundaries. Very important, I think, for the future development and the growing trade in information assets across international bounds. And this is separate and apart from IP, separate and apart from many of the other things we've heard about. This is what we're really talking about, our commercial principles. So on that note, I'll end the presentation and see if I can get some lights on it here.
Thank you very much, Jeff. That was indeed illuminating in every sense. I particularly appreciated the way that you analysed the issue, the problem, and the triple characteristic of the way that information is traded, IP, public policy, and contract law. And I think the chapter that you've contributed and the ideas that you put forward in this presentation really deserve our attention. And it's grounded in practical experience, but also exposes some really complex policy issues. As I'm fond of saying, our middle name, the World Trade Organization, trade, the very nature of trade, or what we think of as trade, that has itself been dramatically transformed in the past 25 years, and we're still grappling with the effect of that. I think you've mapped that out very well. We now turn to colleagues from the US International Trade Commission, who will be presenting on their current work. And I'm certainly looking forward to this. Kate Linton and Art Chambers, who are leading experts in this field, coming back to this question of how do we get a better grip on the empirical situation, how do we ground our conversation in what we can measure and what effects we can assess. So with thanks again for two more people, two more colleagues making the supreme sacrifice of an early start, over to you in Washington. Thank you.
Thank you, and thank you very much for the invitation to join you. We are happy to be here. Can you hear me all right?
Absolutely, yep.
Great. Here is the title of our presentation, Measuring the Trade Effects of Intellectual Property Provisions in U.S. Trade Agreements. My colleague, Art Chambers, and I will do this presentation together. We do trade analysis at the US ITC. Art's training is as an economist and mine is as an attorney. So we try to combine the perspectives of both. Next slide. So a little bit of background on the ITC. We are an independent and bipartisan federal agency. We provide analysis and information to the president, typically the US Trade Representative, and Congress, and there it's the House Ways and Means and the Senate Committee on Finance. We basically respond to questions, trade questions that they ask us. We have separate functions. That is also to adjudicate and enforce certain trade laws and to maintain the US harmonized tariff schedule. The types of analytical tools we use qualitative and quantitative tools. So that can include public hearings, written submissions, surveys of industry. And we also do economic modeling. So on the quantitative side, we both do economy-wide and sector-specific modeling. Our analyses can be retrospective, looking back, or they can be We're going to talk to you today about two studies that we did. One on the effects of free trade agreements that is retrospective, and another that is prospective, looking at the effects of the US-Mexico-Canada agreement. Next slide. The aspects that we're going to talk about for both of these studies is that they both attempt to measure the effects of increased IP requirements under trade agreements, particularly the effects on trade in IP-intensive goods and sectors. We've talked a little bit about what those sectors are today, and there are different ways of identifying them. I'll just begin by saying, as we all know, there are diverging views on IP and its role in the international trade space. The arguments in favor of IP requirements in trade agreements are that IP provides a beneficial incentive to innovation. On the other side, many are concerned that it is a harmful source of monopoly power that can increase prices and reduce competition. What we've heard a lot about today, which I think makes sense, is that IP rules provide a, excuse me, a foundation for the commercialization and transfer of goods and services that rely on IP protections. So we have talked about some of the goods and services that tend to be considered IP intensive. On the left-hand side is a list of some of those goods, those sectors. And on the right-hand side are some IP-intensive service sectors based on the research cited below. One of the most important, and one we've talked about a lot today, are those payments and receipts for the use of IP. Next slide. So here we just have a look at trends in payments and receipts for the use of intellectual property. So if we look at the 1995 period, at the time of the enactment of TRIPS, at the time when TRIPS went into effect, we can see, and then to the most recent data year, 2019, we can of course see enormous growth over the whole period in IP receipts and IP payments. East Asia and the Pacific, so China, Japan, Hong Kong, Korea, Singapore, and India, enormous growth in Europe, growth from a low base in Latin America and Middle East, North America, and in North America, growth, and in Sub-Saharan Africa. Next slide. So what we explored in our 2016 study of the economic impact of trade agreements involving the United States was whether there is a connection between this increased growth that you saw in the IP transactions, payments, and receipts, whether there's a connection between that and trade agreements. So basically, we used both quantitative and qualitative approaches to estimate the effects of change in IP protection on the payments that US firms received for their IP, for the use of their IP. To measure the change in IP protection, we used an index. And in this study, the one that we used is one of the most established. It has been constructed by Juan Chinarte and Walter Park. It is a patent protection index. It looks at 5 categories of protection: duration, which technologies are patent eligible, membership in international treaties, enforcement mechanisms, and limitations. And based on those 5 factors, scores countries' protections on a 1 to 5 across a range of 1 to 5. I will talk in a minute about what those scores generally look like, but I will just highlight here our findings, which is we found that US IP receipts were approximately $10 billion higher in 2010 than they would have been had the patent protection levels remained at their 1995 values. So next slide. So here you can see some of those changes in the index that occurred during this time period. So the average increase in patent protection for all 121 countries that were in the index was from 2.5 on a 5-point scale to 3.3, which is a 32% average increase in protection. For those countries that were TRIPS members in 2010 and who entered into a trade agreement with the United States since 1995, the average increase in protection was higher, 44%. For those countries who were TRIPS members but not in a trade agreement, there was an increase in protection of 30%. And for those countries who were not yet TRIPS members, the increase in protection levels during this period was 23%. So you see a general trend towards increasing protection, particularly in those countries with free trade agreements with the United States. Next slide. And let me talk for a minute about our second study. And let me actually go back and just tell you, I mentioned that effect on US IP receipts, and I didn't really explain it very well for you. That is based on our economic model, which controlled for country fixed effects. And we also conducted sensitivity analysis to evaluate those results. One of the questions I saw in the chat, which was a good one, was about how IP trade is affected by the tax strategies of firms. And so to try to isolate that, to address, to figure out what the effects of those kind of transactions might be, we took countries out of the calculation that are identified in the research as tax havens. And what we found was that, at least for this category of trade, there continued to be a positive and significant relationship between IP protection and trade, and that result was similar regardless of whether you included those tax haven countries or not. Okay, so now moving forward to 2019, and this was our forward-looking study. And again, this was a study requested. Actually, this is a study we do whenever the US is planning on entering into a trade agreement. And it is to identify the likely economic impacts going forward on the US economy and industry sectors. So again, we took both quantitative and qualitative approaches. We did in our IP modeling, again, we were looking both economy-wide as well as in the particular sectors affected by IP. In our IP modeling approach, our goal was to identify the relationship between trade in certain IP-intensive goods sectors and increased IP protections that were required under the USMCA. So the IP-intensive goods sectors that we looked at were those that come out of the literature, and they were analytical instruments, biopharmaceuticals, chemicals, ICT, medical devices, and production technology. And out of those sectors, we looked at the trade patterns to see if we saw increasing trade as IP protections changed. And our measure of IP protection was a different one. We didn't use the PARC index. We used one provided by the US Chamber of Commerce. And the reason we used this index, really, there were two reasons. It was not just focused on patent protection, but all types of IP. So we found it more fulsome, and it also took into account enforcement. And then they had an additionally calculated what would be, if USMCA were to go into force, what would be the increased requirements, protection requirements for the member countries of USMCA. And so that gave us a way to identify the change in IP protection required by the agreement. Now, only 2 of the sectors that we thought might be IP intensive actually showed a relationship between trade and IP protection. And those were, one is called scientific and analytical instruments, and the other medical devices. We had various theories as to why this might be in our discussion, and I would be happy to talk about that more during the Q&A session. But those 2 sectors were the ones that did show a significant and positive relationship between trade and IP protection, and we incorporated those results into our economy-wide model. So next, Art is going to address some of the measurement challenges that we've seen in this work, including the evolution, the way that different industries approach the issue of measuring IP protection, as well as some new approaches. So Art.
Thanks, Kate. So as Kate Linton mentioned, there are sort of several different indices that measure IP protection. This slide just gives you an overview of these indices. As Kate mentioned, they sort of vary by scope in terms of what they cover. So several of the industries focus on patents, but there are also some industries like the US, or some indexes like the US Chambers Index, which covers multiple types of IP. They also vary by the countries that are covered, as well as the frequency of which they're updated. In addition, they vary in terms of whether they just focus on laws on the books, or rather how these laws are actually put into practice. And the data sources vary as well. So they vary depending on whether they cover like de jure versus de facto laws. Across these indices, it's broadly similar where countries rank, which is sort of one of the interesting pieces. So developed countries like the US, Canada, Europe, Japan, they rank highly across all these indices. There are some interesting differences. So for example, just focusing on trade secrets, the US ranks number 1 on both the Lippold and Schultz and the US Chambers Trade Secrets Subindex, whereas the UK is number 2 in the US Chambers Subindex of Trade Secrets, but it's 13th in Lippold and Schultz. And so whether that makes a practical difference or not, you sort of have to delve into the index itself, what the methodology is, how it's constructed, to try to understand, okay, is that an actual difference, or is that sort of an artifact of the methodology? Sort of like Kate said, the indices have different strengths and weaknesses. It's important to understand what the index measures and what it does not measure in terms of both IP types, as well as de jure versus de facto laws. At the US ITC, we have done a little bit of work in sort of combining some of these indices. For example, taking an index that measures laws on the books and then trying to interact it with a measure of enforcement or sort of legal systems or property rights functioning, to sort of combine some of the strengths of different indexes. So another way of measuring IP provision or IP sort of laws is to look at provisions in free trade agreements, or as we call them, sort of preferential trade agreements, the PTAs. So this is just sort of an overview of data sets that code for the presence of IP provisions in PTAs. There are sort of 2 sort of big different databases here, and then sort of another database that's sort of a related project. So the World Bank's DEEP PTA database, it contains 295 PTAs, 120 IPR specific fields are coded. There are more fields coded for other types of non-tariff measures, but just the IP ones, they go from the early 1990s to 2016. The entire PTA database goes back as far as 1958, but they don't have any PTAs before the 1990s that focus on IPR fields coded. It breaks down the IP provisions by type, so patents, trademarks, copyrights. They also include sectoral coverage as well as enforceability, so whether these provisions are binding or subject to dispute settlement. The design of trade agreements dataset, or the DESTA, does a similar thing. They have a broader scope. They cover about 1,100 PTAs, including about 700 with detailed IPR data. They also cover some more detailed fields. So they have 195 IPR fields coded. It goes back as far as 1947, but again, before the early 1990s, most PTAs did not have any IPR fields coded. Similarly, it breaks down provisions by type, but again, they have a few more detailed provisions that are covered. And then finally, Morn and Surbeck, which is a related project to DESTA. This particular data set focuses just on TRIPS plus provisions. So they have 126 PTAs, 90 fields are coded, again, related to TRIPS plus provisions, starting in the early 90s to 2016. And what's really interesting about this data set is it does really let you focus on, okay, what provisions go beyond the requirements of TRIPS, and then it categorizes them according to some of the similar types of categories that we see in the World Bank's PTA database and DESTA. So these provide like a really rich data set for looking across FTAs, comparing FTAs, how these FTAs have evolved, and also trying to understand what is the effect of these provisions on trade. Some of the limitations here, in addition to sort of the coverage, the variables in the data sets are coded as binary, so it's a yes, no as sort of to whether that provision is present or not. And so it doesn't necessarily account for the variation of specific provisions across FTAs. So it's a little coarse in some of the categorizations. It doesn't really account for enforcement or implementation either. And that brings us to some of the measurement challenges, which Kate has mentioned, as well as many of the other presenters. So they fall into sort of in three types. So we've already heard about, IP embedded in merchandise trade. So there are various classifications that exist, and Kate mentioned a few of these that allow us to identify IP intensive sectors. So from the US Patent and Trademark Office or from WIPO. They classify industries by patent, trademark, or copyright intensity. These classifications vary by aggregation, so they don't always have an exact correspondence to the data sets that we use in modeling. So in some cases, you might have a very IPR intensive sector that's aggregated together with some less IPR intensive sectors, and that poses a few challenges in terms of understanding what the effects of provisions are on the dependent variable. As again, other presenters have mentioned, data availability can be a challenge. So whereas data on goods, which can be classified as IP or not IP intensive, data on goods goes back several decades, but services data is much more limited to recent years, and there's less country and sector coverage at the bilateral level. In addition to cross-border trade, IP also plays a role in foreign affiliate sales, foreign direct investment, global value chains, but these data are actually even more limited by country, year, and industry coverage than the cross-border data. This is improving. So as time goes by, the types of things that we can model increases, and obviously people at the WTO, the OECD, and the national statistical agencies are doing really great work to sort of improve the data. So as time moves on, we can do sort of newer and more interesting things. One of the other major challenges involves disentangling the effects. So what that means is we've heard a lot of people discuss, digital trade provisions or other types of provisions that affect the same sectors as IP provisions. So you have multiple types of provisions, for example, in an FTA that all affect the same industry. So for example, IP and digital provisions both affect trading computer software. So the issue is, how do you disentangle the effects of one type of provision from the other? And these provisions, as some folks have mentioned, they're not necessarily randomly distributed. So more rigorous provisions often occur in PTAs that have other high standard provisions, such as digital investment services, et cetera, because PTAs tend to be deep across multiple types of provisions, including IP. So countries are, they're building off of previously negotiated PTAs. They're using templates, like I think one of the presenters mentioned. this might be great from a policy perspective, but it does mean there's less variation across countries and over time in terms of the types of provisions that are in these PTAs, which makes it difficult to isolate the effects of IP provisions from other types of provisions. Finally, again, hitting at this issue of understanding enforcement and implementation. So these provisions data sets don't necessarily account for the level of enforcement or implementation across countries. Some indices do this, particularly the ones that account for sort of laws, how laws are used in practice. We have reason to believe that enforcement and implementation varies across countries, across time, but also across potentially provisions in PTAs. And the PTA datasets themselves don't necessarily capture the nuances around enforcement of specific provisions. In the indices, while they might capture some of the nuances around enforcement, it's still at a broad level. Finally, one of the issues is we expect to see effects in the data, and that's how we sort of identify the effects that Kate mentioned in our reports. So we also have to be cognizant of phase-in periods, both the legal phase-in periods that are present in PTAs, but also just the time it takes to see firms change their behavior, alter their decision-making, and for that to then show up in the data. So it does sort of limit us in how we're able to examine particularly more recent PTAs and understand the effects. Sort of like Kate mentioned, we do sort of retrospective reports as well as prospective reports. So we have sort of simulations to look at the prospective reports. And so a few of the areas for further research, one of them, as Kate mentioned, is incorporating IPR effects into the economy-wide CGE models for PTAs. That was something new that we did with USMCA. And as trade agreements sort of move away from just tariff reductions, but increasingly have all these types of non-tariff measures, including IP provisions, it's important for us to try to take all of those into account when we're trying to understand what the likely effects of these trade agreements are. Some of the other areas for research include focusing on specific types of IP provisions using these great new data sets we have at the provision level, like the World Bank and DESTA, understanding how IP provisions interact with other provisions in PTAs. Again, the IP provisions aren't working in isolation. They're working together with digital and investment and all these other types of provisions to ultimately affect trade and investment and economic growth. And so we want to understand, okay, how do these types of provisions work together? Accepting, of course, that it can be difficult to disentangle these effects. And then finally, examining the effects of IPR, not just on cross-border trade, but also on FDI, on foreign affiliate sales, on global value chains. As we get better data and as we sort of develop new methods, we're better able to sort of tackle those questions, which are richer and more interesting, but also a little bit harder to deal with. All right, so that's all I have.
Thank you very much indeed, Kate and Art. Really very important presentations. I think what you've done is spotlight one of the really significant developments in the 25 years of TRIPS, which is the growth of norm setting in bilateral and regional agreements. And you've helped illuminate for us the challenges, but also the opportunities of applying more effective metrics to understand that impact. And certainly that's one area we'd like to continue the dialogue and explore further, because ultimately one thing we're really grappling with and has come through presentations is the need for a sounder, more inclusive empirical foundation. So thanks so much. Your joint presentation has taken us a very good way in that direction. Our time is tight. I guess that's inevitable with this kind of program. We've tried to pack so much in, but we have two more presentations to come. Both speakers from a Geneva point of view, from geographical extremes. So again, very grateful to our next two speakers. Nigel Corey is Associate Director at Trade Policy, Information Technology and Innovation Foundation, based in Washington, but currently late at night on the east coast of Australia. So Nigel, over to you.
Thanks, Tony. Let me share my screen. Great. Good morning, good afternoon, good evening, everyone. It's great to be here. Firstly, thanks to Tony and Jayashri and the rest of the team at the WTO for the invite to speak today, as well as to take part in the collaborative project around trade and knowledge. My name's Nigel Corey. I'm the Associate Director for Trade Policy at the Information Technology and Innovation Foundation, ITIF, a non-profit think tank based in DC. We look at all of the buzzwords that were listed up here on the slides and that you've heard about today. We're based in DC. We also have an office in Brussels, but we're globally focused in non-COVID times, traveling relentlessly. Within this, I focus on digital trade, high-tech trade, and intellectual property. I want to take the opportunity, the privilege of being one of the final speakers to work on a lot of the good work raised by my previous speakers. In the true spirit of intellectual property and innovation, I get the opportunity to stand on the shoulders of giants in trying to draw out some of the key issues and key trends as I see them to hopefully help inform you about how all of these pieces that were spoken about sort of fit together. And with that, I'll talk about some of the key elements and what I think are some of the key implications for trade, innovation, and development. But before I dive in, I want to make 2 points upfront clear. That first, updated modern rules modern rules for trade and IP will lead to more ideas, innovation, and trade, which is key to spurring economic productivity and developing the tools we need to address any number of sort of global public policy issues, whether they be social, economic, or environmental. Digital technologies have already done so much to change trade in terms of allowing firms and countries to engage in trade far easier. It's changed what's been trade with the increasing digitalization of goods and services. It's changing how economies will continue to engage in the creative economy, as Keith mentioned. And as Stella mentioned, this impact will only grow as more firms and more individuals and more countries adopt these digital tools and join the global digital economy. Because just as free trade agreements between countries increase the size of markets and boost gains from trade, so too does data and digital technologies when combined with digital trade and IP rules. It leads to greater gains from the exchange of data, the ideas and goods and services embedded in them, and the innovations these support. Second, more modern digital and IP rules matter for small and medium-sized countries and developing economies, as economies of scale are central to competitiveness in today's global digital economy and today's global creative economy. Economies of scale have always been important when it comes to trade, but never before have individuals and firms had access to digital tools like the internet that have allowed them to benefit so easy and such low cost. However, if the global economy becomes fragmented into walled gardens, it'll be the smaller and medium-sized economies and their firms and workers that lose out the most. Large economies like the United States and China have internal markets that they can leverage. So it's up to officials from these other countries that if they want their firms to have any chance of developing their own ideas into cutting-edge goods and services in the global market, they need to be pushing for the protection and the rules that provide them with the certainty of market access and protection they need to achieve those, to build those economies of scale. I'll skip through this in the interest of time, and it's been covered elsewhere. So we've found a bit foundational sort of points about the role of knowledge in today's global economy. I'll briefly mention about data specifically, because it's important we sort of ensure we know what we're talking about, and it's not just some abstract legal or trade law term or process. I spend a lot of my time talking to some of the world's leading edge firms about the nature of the problems they're facing as it relates to policies in certain countries that affect how they're engaged in modern knowledge creation and sharing and modern trade. And so this is very real for them, and it's something they're grappling with. And while overall we're seeing sort of the leading edge of its impact, this will surely only grow the longer there's a vacuum in terms of the uncertainty around how current trade rules apply or not to what they're doing. But as other speakers have said, without using bad analogies, data is the lifeblood of the global digital economy. However, the use of data to create value is increasingly important to economic growth, competitiveness, scientific discovery, and social progress. Success in today's data economy depends on how effectively firms and individuals can leverage data to generate insights and unlock value. And this will only increase as we evolve into an algorithmic economy. However, to maximize the value of data, it needs to be able to flow across borders, which it will naturally do, or it will naturally take place unless governments enact artificial barriers against it. And while cross-border data flows can raise legitimate public policy issues, such as data privacy and cybersecurity, the challenge for the WTO and its members is how do they enact or consider rules around data that are not unnecessarily restrictive, that address the underlying concern while balancing it against the major beneficial use of data and transfers of data. Because what we're seeing now is the emergence of barriers to data transfers, and given what's embedded within that data, transfers of knowledge, services, and digital goods. And this is really starting to pick up pace in the last few years. And so this is indicative of the risk to the global digital economy and the ability of individuals and firms from countries around the world to leverage data and digital technologies to engage in trade and innovation in a way that we have never seen before. And so in this vacuum, more countries will enact restrictions that undermine our ability to maximize the potential benefits of these tools. Moving on, I'll briefly mention IP, or actually I'll skip past it given it's Keith did a good job covering the copyright angle. But basically, you just can't really underemphasize the impact that the fact that more knowledge in goods is increasingly critical, but it's easily misappropriatable in terms of firms and individuals can seize it for less than market value, which obviously undermines firms' ability to capture the revenue they need to reinvest in innovation. One thing I have been thankful in sitting on the edge of my seat listening to these speakers is that no one sort of covered off on the bigger picture of why we talk about TRIPS. In terms of its role and IP's role in supporting innovation, as it does in Article 7. And so I think building on Wolf's useful sort of timeline at looking at the development of key international instruments, we need to look at, I suppose, since in the life of TRIPS in the last 25 years, the rise of innovation as a explicit formal policy objective has really come to the fore. And so in this last 25 years, we've seen it come up, and that more and more countries are adopting formal innovation strategies. And so, but what we hopefully will see in the future is that future agreements will include it as an explicit goal, innovation, and bring the various elements together to sort of update the trade framework and the IP framework in sort of explicit connection to the innovation goal in a way that sort of TRIPS obviously laid the foundation for. But as Tony in this sort of effort is doing, there's a lot of work that needs to be done to lay the groundwork, to build the understanding, to put the pieces of the puzzle together in terms of how the role of trade rules as the sort of international extension of the very complicated sort of domestic innovation sort of policies that countries need to implement. And if in case 25 years of slow progress or inaction isn't motivation enough, I think it's also important to highlight what we're obviously trying to head off in terms of where we think the international trade system should be heading. Because obviously the 20th century nature of trade was in physical goods and their main barrier was tariffs, whereas trade in the 21st century is mainly digital and intangible and knowledge intensive. And so it mainly faces non-tariff barriers. So what we've seen is a rise of what we call innovation mercantilism. And this is sad and unfortunate in that the global race for innovation can be win-win, in that in an interconnected world, innovations in one country can be virtually applied to all nations. For example, an innovator in South Korea may come up with a better battery, which can essentially be transferred with IP licensing and whatnot elsewhere in the world very quickly. But the reverse also happens in that countries can systematically prevent innovators from fully realizing the economic gains from their inventions by following a destructive beggar thy neighbor innovation mercantilism strategy. And some countries are doing this, which is really sad to see, in that they're focusing on weakening IP and forcing firms to hand over technology and IP, or just sort of the outright theft of IP as a way to support or expand domestic technology production. And the intention of this innovation mercantilism strategy isn't to maximize the win-win national and global level innovation that we're focused on, and to support the role that innovation plays in driving long-term economic goals. It's to ensure that innovation's outputs in terms of ideas, goods, services, and exports are produced in one's own country. I want to quickly finish by highlighting three implications that I think are key to this discussion, this overall sort of consideration of what we're trying to build here at the WTO and elsewhere around the world. Firstly, new digital rules are much needed, but they're not enough. It requires an additional overlay of regulatory cooperation, and in the context of developing countries, much larger investments in capacity building and targeted technical assistance. Because these trade issues for modern trade involve non-tariff barriers, it draws in domestic regulatory agencies in a way that we haven't really seen before. And there's a lot of work that needs to be done to get them up to speed, so that the new trade rules are meaningful in that they allow firms to engage in trade and innovation while ensuring that domestic regulatory requirements are still being met. And there are some interesting models out there. Singapore, Australia, and New Zealand are pursuing digital economy partnership agreements, which use MOUs for cooperation on new and emerging issues as an overlay to the new digital trade rules that they've already agreed to. Implication number two, connecting to the bigger picture, looking at how the discussions in Geneva connect to domestic efforts to support firms and sectors and the entire economy to get more out of innovation, to get more out of foreign technology, to get more out of foreign know-how. New trade rules are obviously just the international extension of these efforts to focus on what they need to do at home. And this is a bigger part of the challenge that I sort of mentioned earlier, in terms of like innovation itself being a more explicit goal that many countries are following. And it's something that we would suggest that countries pursue through a formal innovation strategy, to connect the pieces together, to talk about digital infrastructure, skills and education, taxes, and all the other pieces of the puzzle that need to come together in a domestic context for these new, hopefully ambitious digital and IP rules at the international level, for them to mean something. And finally, as it relates to in the development context, if there's one piece of advice that I would give to officials and organizations in Geneva, is avoid the zero-sum view of technology and IP and modern trade at all costs. Every national innovation system needs foreign knowledge to upgrade. I think that was the key point that Stella made in her points, in how the vast majority of the economic benefits of foreign technology and foreign investment come from supporting as broader adoption and deployment as possible, rather than the much more narrow gains that come from the actual production of the technology. And so this raises the ever increasingly important issue of absorptive capacity for developing countries, in terms of helping them and their firms and their individuals get more out of foreign technology and foreign know-how. And there are a number of ways that they can do this, but this will be increasingly important as we move along. Finally, here's a lot more reading material for you all to dive into and to dissect based on my work on IP, data flows, data governance, digital trade, and high-tech trade. It lays out all of our recommendations in painful detail. But overall, I'll wrap it up with a final hopeful call to arms, in that If we in the international community, the international trade community, want to maximize global innovation and the benefits that come from global trade, something that's critical if we want to have any chance of addressing any number of shared challenges around climate change, disease prevention, and broader economic growth and improvements of living standards. We need a stronger and more wide-ranging consensus on the importance of IP and innovation to every country around the world. As in the years ahead, our policymakers in Geneva and elsewhere around the world will face a choice in deciding whether they want to join with their partners and embrace a truly global, modern trade and IP and innovation framework, akin to the critical steps that happened in the early 1990s in terms of laying out a truly comprehensive multilateral trade framework. And I'll end it there. Again, thanks Tony and Jay Cherie and the rest of the team at the WTO for the opportunity to present today. Look forward to any questions you might have.
Thank you very much indeed, Nigel. And certainly in this complicated debate, I would invite anyone who hasn't read it. You just need to read at least one article of the TRIPS Agreement, Article 7, which I think was visionary for the time. It says exactly that the intellectual property system is a positive sum game. It's there for the mutual advantage, as it says, of the producers and users of technological knowledge, and it sets it in that context of social and economic welfare. And to me, the policy debates that have taken place ever since then, in a way, all fit into that question of, okay, that's fine in principle, how do you achieve it? So thanks for that contribution to those thoughts. And we will have to continue to press on. Thank you all for sticking with us. Our final speaker, Lucas Spadano, has just recently completed his PhD and worked with us here in the WTO, but is now in private practice in Brazil. Lucas, over to you. Thank you.
Thank you, Tony. I hope you can hear me well.
Yes, you're getting through fine. Thank you.
Perfect. Thank you. Thank you for the very kind introduction and for the opportunity to participate in this event alongside such distinguished panelists. Good day to all. After all the interesting presentations we have just seen, what I'll try to offer is a very broad analytical framework of how trade rules, both at the WTO and at the preferential levels, may impact cross-border knowledge flows from a legal perspective. This short overview is based on a paper that I wrote together with Luisa Tangeri Coelho, and that will be published as a chapter of the forthcoming Trading Knowledge book edited by Tony and Jeshri. A first important conceptual clarification that is that when I refer to cross-border knowledge flows, I am referring to an overarching concept that we have defined to include information and data flows. This image represents the so-called DIKW pyramid, a popular model used mostly in the fields of information science and knowledge management. The essence is that data, for example, binary codes, is only meaningful to us if we combine and process it so that it becomes understandable information. And to make information truly valuable, we also need to assemble it and know how to use it, which is when you can argue you have knowledge about something. It is interesting to observe how intricate the relationship between knowledge flows and trade is. On one hand, knowledge is embodied in technological goods that are traded, as well as in human capital that may be accessed through the provision of services. On the other hand, the general purpose of the creation and transfer of knowledge, for example, when IP rights are licensed or when scientific collaboration occurs, seems to be to obtain developments and results that are at some point traded as new products and processes that solve our day-to-day or our life problems more efficiently. Of course, this close connection is also reflected in the international trade rules. How do they impact cross-border knowledge flows? They do so in various ways. First of all, the promotion of trade generally has the inherent potential to disseminate knowledge, at least indirectly to some degree. So improved market access always helps. Think of trading, say, agricultural machinery. Someone will need to learn how to operate it properly in the field. But that is, of course, not the end of the story. In the paper, we have classified the trade disciplines in 4 categories to help explain the connection between trade and knowledge flows. The 4 categories are: 1, disciplines that facilitate trading goods and services that enable access to information. 2, disciplines that concern incentives for the creation of knowledge. 3, disciplines that promote cross-border flows of knowledge, i.e. the transfer of technology. And 4, disciplines that allow certain legitimate restrictions on flows of information. Within these broad categories, we try to compare what the WTO rules have to offer with new trends identified in a few relatively recent preferential trade agreements. We have selected the 7 agreements on screen, most of them involving the European Union or the United States, given the historic role that these 2 jurisdictions have in terms of shaping the trade agenda. The sample includes agreements with some developing countries, and we also included at least 1 agreement involving China with Australia to try to capture different perspectives. This table is a very simplified version of the one that appears in the paper, which itself offers only a summary of the various disciplines. I will certainly not detail all of them here, but only to illustrate, in terms of promoting the trade of technology enabling goods and services, the WTO rules include 2 important legal instruments: the GATT's Annex on Telecommunications and the Information Technology Agreement, which was successfully expanded in 2015. In terms of incentives to the creation of knowledge, there are disciplines on R&D subsidies, both in the SCM agreement and in the agreement on agriculture. The non-actionable class of subsidies has expired, but R&D subsidies are very rarely challenged, and they are allowed if they are not specific and/or they do not cause adverse effects. The analyzed FTAs explicitly allow local R&D requirements imposed on investors in exchange of advantages, which also shows an interest of states in maintaining policy space to encourage those activities. Each of these rules and their implications are very interesting and may be discussed at length. The same goes for the rules and exceptions concerning data flows, which other panelists have touched upon. But here, given that we are celebrating the 25 years of the entry into force of the TRIPS agreement, I will focus a bit more on the knowledge-related rules that concern more specifically IP rights. The TRIPS agreement, of course, incentivizes the creation of knowledge by requiring minimum standards of protection and appropriate enforcement measures for various categories of IP rights, including patents, industrial designs, software, etc. The logic is well known. From an economic perspective, knowledge is a public good, which means that the use by one person does not prevent access by others. IP rights are a type of intervention in the market that serve the crucial purpose of making sure that the private sector will be interested in taking the risk of investing in quite onerous and challenging inventions, such as vaccines. But the TRIPS agreement does not provide for protection of IP rights at all costs or without limitation. There are various provisions built in the TRIPS agreement that may be generally described as safeguards against the overprotection of IP rights. We have counted at least 17 such provisions. They include paragraph 2 of Article 8, for example, which provides for an obligation not to extend copyright to ideas or procedures as such. They also include compulsory licensing provisions in Article 31 and 31 bis, which governments may eventually rely on, including in the event of public health emergencies. In connection with those various safeguards against overprotection, the TRIPS agreement explicitly states the principle in Article 7, which Tony just quoted, that there must be a balance between the interests of IP owners and society as a whole. So the protection and enforcement of IP must effectively contribute to the transfer and dissemination of technology. Article 66, paragraph 2, quite remarkably, imposes an obligation on developed countries to incentivize their companies to transfer technology to least developed countries, so as to enable them to create a sound and viable technological base. The Council for TRIPS has established a monitoring mechanism in 2003 to supervise compliance with this obligation, which is no small achievement in terms of international law. The FTAs, in turn, typically provide for some TRIPS plus obligations in the sense of requiring signatory parties to expand the protection of IP rights in various ways. As an example, some of the FTAs provide for minimum periods of protection or exclusivity for test data concerning agrochemical products and pharmaceuticals, such as data on clinical trials, for up to 10 years, which is the period of protection set forth in the USMCA for biologic drugs. This has a significant impact on the market and investments required to obtain authorization to market those products. So it is quite controversial, as one would expect. As another example, some FTAs also prohibit requirements to disclose source code as a condition to enter the market. While this principle seems less controversial, the CPTPP parties have negotiated an exception for software used for critical infrastructure, the exact meaning of which is yet to be confirmed. So the practical impact of such new provisions still needs to be evaluated over time. On the other hand, the FTAs also typically include various safeguards to avoid the overprotection of IP rights, including, for example, explicit references to fair use rights. The CPTPP acknowledges the importance of maintaining a rich and accessible public domain, which again reflects the idea of balancing the interests of IP owners and the general public. So to finalize, the paper presents some conclusions as to how the trade rules impact cross-border knowledge flows, and explores whether it would be needed or desirable to improve the WTO rules, for example, by multilateralizing some of the rules found in recent FTAs. Our conclusion is that there surely is room for improved commitments, for example, in the area of migration of skilled workers under the GATS, which is key to disseminate the type of tacit knowledge that Stella referred to in her earlier presentation. The agreement between the EU and Colombia, Peru, and Ecuador sets a useful example by encouraging the temporary movement of R&D equipment and skilled researchers, although ideally this would involve more than best efforts. There's also room for updated consensual rules in certain areas, digital trade being one of them. But we consider important to note that current multilateral rules already play a very important positive role in promoting knowledge flows. And the TRIPS agreement in particular seems to strike a very fine balance that one should be cautious about disturbing. In our view, the issue of strengthening the protection of IP rights, including exclusivity periods, should be assessed carefully, at least until there's clear evidence showing a positive impact on the creation and dissemination of knowledge. It's probably safer to leave those to the regional or bilateral level, where countries may decide upon the convenience according to the interests and the overall bargain at stake. There are various other interesting ideas for further research, such as in the ever so important area of scientific collaboration, but I'll leave those for the follow-up questions if there is time, or for another occasion. So I'll stop here. Thank you, Tony.
Great, thank you very much, Lucas, and thanks for compressing so much into this limited space, but pointing towards, in two directions, to further research, to what needs to be done in the future. And I think you've linked back to some of the earlier presentations, and I'm grateful to all of the panelists. Indeed, there's been already some cross-conversation and reference between the panelists, which shows that we've selected a very good panel. There's been so much content, and this has pushed us well beyond our time limit. So I'm very apologetic to the final speakers and to all the audience for staying with us. But do stay with us, because we still have two key figures. Jayashri will now take over as moderator, and our commentator, who's one of the leading experts globally, Sasha Vincent from WIPO, who's done fantastic work in this area. So please stick with us, and thank you very much to all our panelists. Jayashri, over to you.
Thank you, Tony. If my video could be unlocked by the host. Thank you. So this has been a fascinating discussion. Thank you, Tony. Thank you so much for putting this together. I had no role in that, but we've had such interesting presentations. Jocelyn, I think all the panelists are still there, other than Wolf, who had to leave for another meeting. So we've had excellent presentations. I want to also thank the speakers, Jocelyn, Mira, Keith, Stella, Wolf, Jeff, Kate, Art, Nigel and Lucas. Oh my God, that was fantastic. We had such a great discussion. Now, I will not take up more time between you and our very, very expert commentator from the WIPO, Sasha. Welcome to the program, Sasha. And yeah, take it away. So you have the floor.
Thank you, Jayashri, and also for organizing this and for inviting us over at the WTO. Look, it's hard to comment on the various papers that have been presented. I wish to just outline, how we as economists at WIPO, think that the afterlife of the book should look like in terms of, two main strands of work. The first contribution that we're trying to make is to analyze the surge of intangible assets and to create, specific linkages to intellectual property. As many speakers said, a lot of intangible assets are not identical to specific forms of IP and vice versa. And the second point I want to raise as part of our contribution is how we can help shape the new IP ecosystem policy agenda. After the book, I will argue it's also a time for most likely a new IP policy paradigm that we can all work on. Now, in terms of the first one, analyzing the surge of intangible assets and linkages to intellectual property, it's very important to actually identify and put figures on the surge of intangible assets. Not only how many patents are filed or how many IP payments are being recorded, but also grossing up the value-added contribution of intangible assets to the economy, to specific sectors. So we analyze, for instance, the coffee sector or the smartphone sector. And then even at the product level, to make some sensible quantitative contributions. So at the product level, not too long ago, we looked at specific smartphones and concluded that about 42% of an iPhone sales price is actually a measure for return to intangible capital that is embodied in this phone. So, and then you need to go one step further and identify which IP forms underlie this specific intangible asset return. And sometimes you will identify that there are several, a bundle, and then other times the value might just exist without any specific direct contribution of intellectual property. And here, I think in this discussion, we've always said trade and IP, trade and knowledge. Some contributors, specifically on the text front, started breaking it apart a little bit, right? I heard licensing here, etc. What's very important is that once you open this IP box, the whole array of financial and non-financial transactions that exist. So, patent pools, unrecorded intra-company transfers of intellectual property, cross-licensing, mutual sharing of technology. So it's quite important that we, next to trade and ideas, we put a taxonomy of actual intangible assets and then also actual IP transactions that might take place. I think we're only at the start of this, but the book makes an important contribution here. Now, what's kind of like a bit annoying is that, of course, all non-pecuniary transactions are not recorded, right? That's kind of to be expected. What's more worrying is that in terms of real commercial transactions, which should be recorded, only international trade transactions are, documented, and very imperfectly so, as mentioned by other speakers in terms of IP balance of payments. So that's a very unsatisfactory outcome as outlined before. And what I do with my co-author Tom Neubig in the book, we even argue that basic only data point that we have is strongly influenced by distortions due to tax diversion of multinational entities. So about 35–40% of these transactions are either over or under measured. So again, I mean, as afterlife to this book, Jayashri, I think it's going to be very interesting to further these taxonomies and further unpack these linkages. Now, as a second point of WIPO's contribution, I think it's very important now to shape the new IP ecosystem policy agenda. And this is a new role of WIPO, in fact, as it just has created under the new DG a WIPO IP and ecosystem sector. Now, I think we've been already quite involved in fostering innovation ecosystems, and the policy paradigms there are quite known, right? We know it's not the WTO mandate, but you know, for other innovation agencies, possibly, we know how to do that, right? What are innovation ecosystems and how to foster them? What's more groundbreaking is what is an IP ecosystem, or an ecosystem where trade, you know, where ideas are traded, right? So, for instance, how do you spur licensing, right? Inbound and outbound, right? How to foster the pooling of IP for specific technologies when it's scattered, you know, across market participants. How to deal with the issue of standard essential patents, you know, how to value IP. So this is an open and new policy agenda in WIPO, and you know, together with the WTO, hopefully, we hope to make an important contribution. So it's a new policy paradigm, which I don't think anybody has even conceptualized quite yet. Let me conclude here because we were really, you know, running out of time. With a big thanks to WTO, but also in particular Tony and Jayashri. I think the book also for me personally is quite a milestone, because I personally, although economist, trade economist, I never was a GATT person. So I jumped immediately to, you know, the electronically traded services, as you remember, and this was like in 1996 to, you know, up until 2005, I think my last presentation at WTO. And always, I was very shy about this topic because, you know, obviously for hardcore economists, it was a bit, you know, aloof. So I always prefaced any sort of talk that, you know, that whatever I was doing, there was a little bit asking for the moon at a very inappropriate time, because of course, you know, trade negotiations were faltering over agriculture and not really, you know, things like digital trade. But I think with your book out there now in the open, you know, with this milestone, I think there's no reason to be shy anymore to, you know, to research these things and to advance the policy agenda at WTO and at WIPO as well. Thank you very much, Jayashri and Tony, for all your work.
Thank you so much, Sasha. You packed quite a few ideas into your two main ideas that you put out there. And I'm sure this will provoke a lot of discussion in addition to all our speakers who have already spoken before you. Now, as you know, let me just go over, because we've gone through so much. I think we need to kind of recapture the essence of what we've discussed this morning, and then we'll go to the questions. So we all know, and we've all acknowledged that the way knowledge flows now across borders has changed fundamentally since the TRIPS agreement and since the invention of the World Wide Web, as Tony put it. So this concept of how do ideas and how does knowledge flow across borders is a question that we need to ask. That's the conceptual question. That's the fundamental question. How has it really changed? And then the question is, how in a certain measurable sense? So how do we measure this change? What has changed? How do we measure it? Which is, again, very tricky, as Jocelyn told us. And as there was a question from the audience to Jocelyn about tax and how these statistics are distorted by the sophisticated tax avoidance schemes, which Sasha has commented on, and his entire chapter with Tom Newbig is about that. So there are answers there, or at least the questions have been articulated in a way that kind of leads us to what we should be looking at and how to make sure that tax doesn't distort these flows. Now, I know from US ITC presentations by Kate that one of the ways that they've kind of taken into account these factors is to take out the tax havens. But and and that whether the results hold with or without the tax havens, that is one way of looking at it. So there are measurement problems, which we have looked at. I mean, Sasha brought another very interesting dimension into it, which is the value of intangible assets as such. How do we measure not just the way, how much knowledge is flowing across borders, who is creating the knowledge, who is buying, who is receiving the knowledge, and so on, but also what is the value of these of this knowledge, and how much, what kind of measurements can we have for that. Then we have the question of the impact of these knowledge flows on development, where Keith Nurse very nicely took a very specific sector, which is the creative economy, the copyright creative economy, as he called it, which kind of looks at how the digitization of flows and the digital economy in general can actually encourage the creative economy in the developing world. But what was striking in what Keith Nurse told us is how it's very little that is being monetized. Very little of the monetary effects are really going to parts of the developing world, in particular Africa, which we know has so much creativity and yet gets only 1% of the music copyright revenues, for example. And even Latin America and the Caribbean, Keith told us, gets very little, 5%. I mean, that's crazy. That's very little. And whatever is going on with the Asia Pacific region, most of it is really distorted by China. So what is the outlook if you remove China? So these are extremely interesting questions on the impact on development. We had Stella speak to us on how trade actually fosters knowledge flows, knowledge spillovers from global value chains, for example. And there was a very, very specific figure given from the research that Stella has done, which is that knowledge spillovers boosted innovation in the countries that were involved with the global value chains by 5%. Relative to those not involved, I presume, with global value chains. So this, I think, gives us an interesting idea of how trade and development, how trade and innovation are kind of interlinked. There are many more chapters. We didn't have all the authors in this program. So there are many more chapters in the book itself which talk about this, the interrelationship between trade, economic growth, and trade and innovation. Now, the question is, how do developing countries really harness these new technologies, these digital technologies, the new digital economy, which is a reality now? How do you harness these new technologies for development? How do you access knowledge flows? I think it was Kate from USITC, if I'm not mistaken, who talked about how, while on the one hand, you know, knowledge flows more easily because of the digital economy, but misappropriation, or maybe it was not Kate, I forget. Misappropriation is equally easier with the digital economy. And therefore, how do you actually ensure that the creators of the knowledge, the creativity is not challenged or is not hampered by excessive misappropriation or of such new, innovative, and creative works. Now, the trade rules aspect was very nicely brought out by many speakers, Meera being one of them, where she gave us such a clear overview of the FTAs. I know that we have to read her chapter to get more details because she just focused on very little in her presentation, very little that is part of her chapter. There's a lot more in her chapter, but how it is essential if developing countries have to benefit from new technologies such as the Internet of Things, such as artificial intelligence, and so on, how it is necessary to ensure that data flows freely across borders and that there is no excessive protectionism involved here, like data localization, etc. And she gave us a good overview of how the new FTAs, the more recent FTAs, deal with these kind of issues. In particular, the CPTPP, which she took as an example, but then kind of padded it up with what's going on with the European Union, how the European Union has a little more on the right to regulate. At least that's what I got out of it, that the European Union gives more freedom on the right to regulate, and how RCEP, the newest, where China is involved, has really given much more space, policy space, as she called it, to deal with these, to deal with regulation. Now, how much of that impacts and what is going to be the measurable impact of these very different trade rule frameworks is something that needs to be studied. And that is something for the future, particularly for economists who need to study the impact of all of this. Wolf-Meyer-Evert gave us a good overview of regulation, the international IP regulation, as starting from the earliest up to TRIPS to post-TRIPS kind of laws, including soft law, and also talked about other technical solutions and the FTA taking a very specific example of ISP liability. And then we had Jeff. Jeff was very clearly talking about commercial transactions, a bit different from international rules and the international rule framework, but very clearly telling us that for commercial transactions, there's something going on here. You can't just leave it to the way it is now. We need some rules here, and we need some common principles, some principles that need to be agreed to, so that the flows across borders in terms of licensing and commercial transactions are not hampered. And he gave us very specific examples of what needs to be actually agreed to. And hopefully, there will be a focus on this before too long to look at how new rules can be made on this. And last but not least is Lucas, who very clearly told us not just looking at IP rules, but looking overall at services as well as other provisions in WTO law, to look at what needs to change. So Lucas, again, I would recommend to all in the audience to pick up that chapter, Lucas's chapter, because he's very forthright, not being constrained by any institutional frameworks, not belonging to any international organization. He's very forthright on what needs to be done and where we can pick on the examples, some examples or in FTAs to look at the new international trade framework that will facilitate cross-border flows of data, cross-border flows of knowledge, cross-border flows of information, assets, and so on. I'll stop here with my little summary. I will ask questions to the panelists that we have received from the audience. So for Jocelyn, we had the tax question, which I think more or less has been answered, so you don't have to get into that. Let's go into this question. What can be done to get better data at the international level, including at the international level? It has to come at the national level and then get on to the international level. So what can be done to get this better data? Could corporations be required or incentivized to make their data available directly to enable better trade policy making? So that is a question for Jocelyn. May I request you as panelists to just note down your questions, because I'm going to run through the questions and then give all the panelists just one round to answer the questions and to add any final comments. So Jocelyn, that was your question. I hope you got that. If not, I can repeat it, but I presume you have got that. For Mira, the question was with respect to Africa. Jocelyn, do you want me to repeat your question?
No, all good for me. Thank you.
All right, thanks. So, Meera, the question to you was, what about data flow commitments made in Africa? Do you have any, could you throw any light on that? Because Africa is not involved with any of the FTAs, or I should say many of the FTAs. And so do you have any idea about that? I am ignoring for the moment COVID-19 type of questions, because that, as Tony said right at the beginning, is not for this particular webinar. For Stella, the question is about agricultural productivity. I think there's been a bit of a misunderstanding of what you said. You basically said that that productivity improves much more. With global value chains and the technology transfers. In fact, the productivity is much more than agricultural productivity. So I think there's been a misunderstanding, so I won't really get into this question. But one question from the same speaker, presumably, is, are there particular areas in which you think SMEs are slow and struggling to adopt, despite being part of global value chains? So we will now take up more questions. Wolf's questions I will ignore because he's not here, so we'll send it to him by email. Now, the questions to the US ITC. To Kate in particular, does the US government have programs supporting IP enforcement capacity of developing countries, and LDCs included? So that is the first. The second question to Art from the US ITC is, how do you consider TRIPS Plus provisions when negotiating FTAs? So I don't know if, Art, that's the right question for you, being the economist and looking at the methodology. But these are the questions. Maybe Kate can take up that last question too. So these are the questions that have come from the audience. There are no questions to some of the speakers, but that doesn't mean that you won't get your turn. You will get your turn in the order that you have spoken in order for you to give any last comments or any reactions to the other panelists, for example. Okay, so with that, I will go in the order that we first had the panelists speak. So Jocelyn, you have the floor first. Jocelyn, over to you.
Yes. Thank you, Jayashri, and thank you to the colleagues who raised these questions, and also for all the very interesting presentations we've had in this webinar. Concerning what can be done to get better data, well, I think, sorry. Can you see me? Because I can't see myself.
Yes, we can see you, we can hear you.
Okay. Okay, so what can be done to get better data? Well, 10 years ago, new international guidelines were released, the revision of the balance of payments manual and the more focused manual on statistics of international trading services, which included some clearer guidelines as to what needed to be measured. What types of transactions do you want to measure trade in knowledge? Well, I think the first step would probably be to get compilers to pay more attention to those. Doesn't mean that they will be able to do everything, but at least if there are some priorities that are set by the users of the information, including policymakers, that would give a better sense to compilers to identify where priorities should be given in the collection of data. And for sure, this is an area where this is necessary, in particular, in the context of all that we've heard today. Of course, when it comes to giving incentives to corporations to provide data. These are avenues that certain statistical offices in certain economies have explored. But for sure, they are the ones holding the data, and it's only through them that we will be able to get better data. But there is a kind of imbalance in the knowledge, if I may use this word in that context. An imbalance in the sense that these corporations are often based in a very limited number of economies. So it's also about international cooperation or transnational cooperation of compilers to actually identify how to improve the quality of the data overall. And I will stop here.
Thank you. Thanks, Jocelyn. Absolutely right. Because while the new manual, asks for all kinds of data, but as you showed us on your slide, very few countries are actually reporting it. So the IMF, which really does this new manual, I mean, they have to really train people in the countries to kind of, improve, to kind of share best practices and to show how the data can be improved. Because everything, I mean, bad policy making is based on bad data. So you just need better data to have better policies. So I think it is so crucial that BOP data, balance of payments data, however flawed it is, really needs an improvement. So with that, let me move to Mira. Mira, you had some specific questions to you. Plus, if you want to add anything, this is your chance. Over to you, Mira.
Thank you so much, Jasri, for the wrap-up, for the very helpful wrap-up of the entire webinar. And thank you also for the question. At this point of time, I'm unaware of any data flow commitments within Africa. And here a general note must be made that in recent digital rulemaking in the area of digital trade that I sketched, traced in my presentation, developing countries have been somewhat at a disadvantage. First reason for this is, of course, that very often in this preferential venues and coming into an agreement with a more powerful economically country, they are rule takers. So they simply take the rules and make concessions as to the wish of the other party, which of course comes with a certain danger that some of the rules that they commit to in these trade agreements might not be actually in harmony, in compliance with their domestic laws. Or very often they don't have domestic laws with regard to certain important issues, such as the protection of personal data, for instance. With regard to the African position, however, on digital trade, what has become clear is that in the area of the WTO negotiations and the joint statement initiative, is that that the African group and India are one of the few sort of WTO members that are definitely against efforts to move towards a treaty, an agreement on electronic commerce, and even again against some sort of not so important or taken for granted already measures such as the ban on custom duties for electronic transmissions. What those countries basically argue is that they need more time, and they need more time to be able also to be able to monetize on the foreign data flows, which come very often from big transnational companies, which might become then dominant players in the domestic markets. And they need to somehow also protect their domestic industries in order to be able to actively participate in the global digital economy. This is a valid argument that should be taken into consideration into ongoing and future negotiations, thinking perhaps of certain sequencing of the obligations or certain different levels of commitments, so that those countries again can become part of this digital trade framework. India has different reasons for this. India has had bad experience with the information technology agreement and losing market share in IT goods, and this of course had political implications as to domestic environment in India, and then created a sort of a negative climate also to newer digital trade agreements within the WTO, but also with RCEP. So as you know, India is not part of the RCEP at this point of time. Thank you so much.
Thank you. Sorry. Thank you, Meera, for your very, very thoughtful, thoughtful ideas there that you've put forward, and the fact that you are sympathetic to some of the points of view that have been expressed in the new negotiations that are going on, or the current negotiations going on in the WTO, which are plurilateral. So I know that Nigel will probably have different viewpoints on this, and gear yourself up to say those things, Nigel, when it comes to your turn. So let me move on to Keith. Keith, there were no specific questions to you, but I'm just trying to see if the last question is something that I can throw to you. But I think I will, let me just pass the floor on to you, Keith. There have been a lot of inputs that have come in about the impact of IP and the digital economy on development in developing countries, and coming from the Caribbean, not just for the creative economy. If you have something to share, having heard the whole webinar today, so go ahead with that. Yeah, right? Keith, you have the floor. Keith may not be there. He might have left already because everyone is busy doing other things. So Stella, yes. There were some specific questions to you on SMEs in particular, but please add whatever else that you want from what you've heard that you would like to add, having heard the other panelists, if you have a question for the others or anything like that, right? So Stella, over to you.
Thank you very much, Jayashree. So yeah, it was really an interesting discussion indeed, because yeah, even though it was just presentations, it was really nice to see the references to other papers, and that we actually do in the end talk about the same thing, just from different angles. Just briefly to the question about SMEs and what particular obstacles or what particular technologies they do not adopt. I think one of the major issues that I wanted to allude to is that even in high-income economies like the EU, there seems to be some sort of divergence between smaller companies and larger companies in terms of digital technology adoption. That there's an OECD study that basically shows that larger, more productive companies are growing in terms of productivity much faster than the small, typically less productive one. And there's basically a divergence in productivity. So while normally the smaller ones tend to be a bit less productive, less capital intensive, this parity has been growing. And basically one of the culprits they name in their study, and they sort of identifies exactly these barriers to digital technology adoption. And that's actually reflected in the EU strategy on digital adoption, really pushing for much broader adoption of digital technologies, because in the end, the digital kind of structures that underlie digital technologies then give you access to adoption of many other types of technologies. So when smaller companies don't hop on that train, they will basically keep losing further and further. So that was sort of one of the points I wanted to make. And of course, that then even like becomes more acute when we talk about developing countries where the digital divide might be in brewing and threatens basically the degree to which developing countries can benefit from digital technologies, where the benefits really are large. And yes, so I think we've been already discussing a lot, so I'll leave the floor for the rest of the panelists, just saying a big thank you.
Thank you. Thank you for joining us, Stella. That's very nice of you, despite having moved on and so on. So, Wolf, if you are back, because I did see some action. Wolf, are you back? No. Okay, so Wolf is not back. Jeff, we move on to you. There were no questions for you, Jeff, But do you have anything to add to what you said? For instance, was my summary okay of what you were trying to say? And maybe you want to also, kind of add in the light of what you heard in the webinar. So whatever, the floor is yours for your last comments, additions, or questions to others, or comments. Yeah, so Jeff, over to you.
Thank you very much. And thank you and to Tony as well for putting the seminar. I think this has been very enlightening. I've taken tons of notes, lots of food for thought. I want to just stress a couple things. First of all, though I emphasize the commercial aspects of trade and information, that does not take away at all from the importance of intellectual property regimes. The importance of TRIPS has been repeatedly emphasized here, and yes, it has had a tremendous impact. So my presentation wasn't necessarily to suggest that IP regimes aren't important. They are. They're extremely important. Recognition of property rights is important to development and to trade. By the same token, just having an intellectual property right, I have some clients that have lots of these beautiful patent certificates on their walls, but if you don't use them, if you don't put it to use, if you're not commercializing, exercising the leverage that's given to you by that property right, then what do you have? And so the whole notion of commercial law and commercial regimes falls into a couple different categories I just want to emphasize. First of all, it is really a recognition of what trading practices are. In fact, it is not necessary. It's to allow and to facilitate transactions in assets, just like with sales of goods. Let's just think about the lawyer who's given the task of drafting a sales of goods agreement. Yes, there are going to be very specific things as to the transaction. Very much, there are going to be, various things that you have to look at, warranties, disclaimer, whatever it might be. But there's an international convention that recognizes certain general trading practices. There goes the lights again. We are going to conserve energy here in this firm. At any rate, the point that I want to stress is that if you go and you had to look at a drafting a contract, you have background rules that are recognized. And there are background rules also in IP transactions. I do think that licensing has particular characteristics. There are lots of commonality. And all I want to emphasize to this group is, in addition to looking at IP and IP regimes and the like, to trade in information assets in this century is at least equal, if not greater, than in terms of value, in terms of importance, than the goods aspects. And so I really what I think I'm calling for is, can't forget the commercial side of transactions in not only in IP, but also in information assets broadly conceived. We need to think about it. We need to create rules of the road to facilitate that trade. And that's really the thing I had to say. And by the way, yes, your summary was excellent. Mine goes on and on. You put it very succinctly, and I do appreciate that.
Thanks, Jeff. It was lovely seeing you. Lovely that you were able to participate in this, despite the early hour, as Tony said, in the US, Texas. So Kate and Art, I will put you together because I'm not sure who's going to take those questions. I think mostly it'll be Kate, the two questions that were raised. So over to you, Kate.
Thank you. And thank you so much to our conveners and to the audience and to the panelists. This has really been a great experience this morning. And I think I will mostly take the two questions and then defer to Art for a last remark. So the first one, which I'm really glad was asked, was whether the US government helps in capacity building in IP enforcement and IP protection. And the answer is yes, many branches of the US government do that. One of the best, I think, or the most robust, is done by the US Patent and Trademark Office through what is called their Global Intellectual Property Academy. which has many programs throughout the year for people throughout the world, both virtually and hopefully in-person programs looking forward. So I'm happy to provide that website link to you all so that can be disseminated. Another one is the Commercial Law Development Program of the Department of Commerce, as well the Copyright Office, the State Department, all branches of US government are out there providing information and capacity building. So I'll be sure to pass that all on to you to be shared. The second question was about TRIPS Plus and developing countries and FTAs. So I did want to clarify that the ITC is an independent body. Mostly we do research in this area. We do not negotiate free trade agreements. That goes on in the executive branch with the US Trade Representative and the other executive branch agencies. What we do try to do is to inform those negotiations and decision-making by providing independent information, objective information. And in that regard, I just say that we will have a study published in July of 2021, which it will be a follow-up to the one we did in 2016. It's requested by Congress, and it looks at the effects of our various free trade agreements. So I would commend that to people's attention, and our website has those studies as well as studies on COVID and other ones that may be of interest to people. So that's all for me.
Yeah, and just really quickly, there is some literature on this topic. There are a couple of papers, Maskas and Ridley 2019, as well as Campion Duenas 2018. They both look at the effects of IPR provisions, and they do break it down by income groups and consider developed versus developing countries. I'm sure there's a broader literature out there, but those are the first two that come to mind. So I would encourage people to look at those. The Morn and Surbeck data set that I mentioned, there are developing countries that have PTAs with TRIPS Plus provisions. So if you can look in that data set, potentially you could use some variation in there and an interaction between developing or developed countries and a TRIPS Plus provision to try to estimate some sort of average effect. If you're talking about sort of a prospective model in like a negotiation, you might be able to rescore one of the indexes for the change in the law and use that as an input for an AVE or CGE model or something like that. So there's a couple different ways you could do it. Thank you.
Wow, that was fantastic, Art. And your presentation with all the details in it, I think even though it kind of went over the time that was allotted to you, but it was so useful. It was so useful for those of us who look at these indices. And I know that the PAC Ginarte index has been there for a long time, but I had no idea there were so many new ones that had come out. So thank you so much for putting out all of that. So we go now to Nigel. So Nigel, you have the floor now to kind of to give your last remarks and also to react to anything that Meera said. I thought you might have some reaction to that, so I leave it to you. Okay, over to you, Nigel.
Thanks, Jayashri. And you've done a marvelous job summarizing all of the various strands of the issues that we've raised. Just a quick question to add to Meera's point. There are 5 countries in Africa involved in the WTO JSI talks, Benin, Nigeria, Cote d'Ivoire, Kenya, and Cameroon. And I think their involvement alongside other developing countries is very useful for them because it's been a deliberative process. There's lots of workshops and panels to help them from officials from those countries and elsewhere around the world understand the various proposals and the issues at hand so that when it comes time to actually negotiating, they know what's on the table, they know how it affects them, how it's played out in other countries. And so I think that's a type of understanding, sort of building of understanding that needs to take place on these issues more broadly. Secondly, just in response to India, I think unfortunately what Meera raised in relation to India in terms of it opposing the renewal of the moratorium on digital duties is disappointing given it was enacted in 1998 and one of the more sort of far-reaching examples of foresight by WTO members about how to protect what was then the nascent sort of internet economy. And so to think that that should be overturned, given it's sort of a landmark or a foundational stone for the WTO's work in this area, is really disappointing. And India's broader approach to these issues on data localization, data flows, data competition is sort of indicative of the broader risk of a protectionist-based industrial development sort of strategy, even though it's home, obviously, to a very large, successful, globally competitive services sector that would stand to benefit from a updated sort of digital train framework. But with that, I'll end it there. Again, thank you for the opportunity to comment and to take part in today's panel.
Thanks, Nigel. I know you went on about India, but on your map, the slide that you had of your global map, India wasn't the worst, right? You had China much darker in color, and India and US were about the same color. So maybe you want to say something to that.
I need to update my map, but yeah, you make the good point. China is by far the world leader in many of these digital protectionism policies, but I take your point.
Yeah, thanks. That was a nice side show with us. Okay, so Lucas, now you have the floor. You gave a fantastic presentation, but I know that you have much more to say. Don't think there was any specific question to you, but you've heard the others, and a lot of them made presentations on trade law and how it should be. So if you have anything to add, which you thought you didn't have enough time for because you were one of the last to say, so please go ahead. You have the floor now.
Thank you, Jayashree. This has been great, really. I think I would only encourage everyone to read the Trading Knowledge book when it is published. For sure, there is so much more interesting aspects that many of the speakers have their contributions in the book, and it will be very interesting to read all of them in detail. Maybe one general last comment to take one last question that I saw about the structures that exist in the WTO to contribute to technology transfer. The WTO, of course, is a negotiating forum. So it provides space for countries to collaborate. And of course, it depends on members. The WTO will not act necessarily in itself. And it also provides a set of rules that as I mentioned and Tony mentioned, the TRIPS agreement, it really reflects the principle that the idea of IP protection is to strike a balance between the rights of IP owners and the benefits to society. And likewise, other sets of rules will also allow balancing different interests, and mainly they will allow for domestic policies that will contribute to technology transfer. So there's no incompatibility between the WTO rules and domestic policies that will incentivize that. There is Article 66, paragraph 2 of the TRIPS agreement, which is specifically related to incentives by developed countries to least developed countries. It would be, of course, great if there were similar devices also for developing countries more broadly. But in any case, I think the key message is that there is room for domestic policies that favor tech transfer. And the key point is how to find the best policy standpoint there from each country's perspective and each country's needs. So I think that's it for today. Thank you so much, Jayashree and Tony, again, for the invitation. It's been a pleasure.
Thank you, Lucas. And that was very thoughtful. And thank you for taking on that question, which you saw in the Q&A. So that was very helpful. Sasha, if you're still here, would you like to add anything? Having heard all the questions and the reactions, would you like to say something? Are you still here? Sasha doesn't seem to be here. Okay, so with this, we come really to the end of our very interesting webinar, which really the amount of information, like Jeff said, you know, I've been also scribbling in my notebook, and there's so much that one learns. from all of this. So from all of the speakers, I would like to thank each and every speaker for having participated, not only in contributing the chapters to the books, but this wonderful presentation where you have updated us on specific issues in a very succinct way in this book. I would actually like to add my thanks to the WTO in general, but to Tony in particular, for having recognized my contribution for what it was worth. Tony took the far heavier load on this book. I will openly acknowledge he did a lot more. And if the book is a success, it will be in large part to Tony's contributions. So thank you so much for having me here, having pulled me out of retirement to be part of a WTO event. I'm always proud to be associated with the IP division's events. Thank you very much, all of you, the audience. I know we've dwindled now from a peak of 180 odd participants to now 80 odd participants, but that is only normal given the length of this webinar. I'm sure everyone has taken away something. And for those who stayed on, thank you so much for staying on. So with that, I hand the mic back, really, the floor back to Tony or the WTO team that wants to wind this up. Over to you, Tony.
Thank you very much, Jayashree, for taking us through what was a really fascinating, concluding conversation, way beyond what even we'd hoped for. Also, in terms of the time spent, and indeed, thanks so much for those who have been able to stay on. We've learned a little about time management for our future webinars, but we're very grateful for those who've sacrificed their time, particularly in exotic time zones. And one thing that can be said is that every minute of this webinar was packed full of insight, and we're enormously grateful for that. We do want to follow up, and so we encourage anyone who's still tuning in to please keep in touch. The next event in this series will be a webinar on trade and IP and competition, also one on the economics of IP, if you like, an even more deeper analysis of some of the issues we've been discussing. And of course, the launch event of the Trade in Knowledge book itself, which we want to use as a springboard for a fresh wave of conversations along these lines, but more concretely, research and possibly even, we hope, a follow-up volume, because it's a fast-moving area and there's a lot of material that even in this, well, certainly today, but in this project, we haven't been able to cover already. So we do have an eye on the future, and for anyone with an interest in this area, we certainly encourage you to keep in touch. I hope that the wonderful range of speakers that have contributed today just give you an idea of what the possibilities are. It's truly encouraging and inspiring, and we're enormously grateful. So please keep in touch, and we look forward to catching up with you at the very least in our following webinars, at the book launch, and in the subsequent work ahead. And thank you very much, Jayashree, for coming back from an extraordinarily active so-called retirement and steering us through this final conversation so adeptly. So with that, the team behind the scenes who've been tearing their hair out, pulling this whole thing together and keeping us on track. Fatima Chowdhury in particular, Megan McCann, who's helped pull the questions and answers together, Karen Russell, who's made the mechanics of the work, of this work, Josefita Parra de Leon, who's helped us with this series in general, and of course the technical team who've pulled out all stops to keep us in touch with each other and to make this material available. This will be available as a follow-up in future. This material will be available online, and we'll be looking forward to making use of this in our outreach and our technical assistance, as has been mentioned, for the WTO membership. That's it, and thank you so much, and thank you so much for your time, your patience, and above all, your interest and engagement. So a very good day, a very good evening to you all.